May it please your lordship. Now, with the consent of the other side, I'm mentioning item number 42 of today's hearing list, where the constitutional validity of an OM, which nullified the orders of the division racing.
Oh, you can't hear. Put the microphone on.
Well, with the consent of the other side, I'm mentioning item number 42.
What
of
is
today's-
42?
Yes, of today's hearing list,
Yes, what is it?
relating to reservation where an OM,
Yes.
which has nullified the effect of a judgment of this.
Item
honorable
number
court.
42.
Yes, well, 42 and connected matter.
Huh.
These are the two
42
orders.
is some writ petition.
Yes, lordship, there we have challenged the constitutional validity of an office memorandum
Very well.
of January of 2023,
Yes.
where the honorable division bench had passed an order in March of 3rd, transferring all the matters from the single bench to the division bench of the chief justice.
Let the item be called. We'll hear you. Yes.
May it please, your lordship,
Sorry,
I
President.
beg to mention item number 25 of the day list. Kindly this matter may be adjourned for the day.
25.
25, lordship, 25.
Adjournment.
Yes, lordship.
Why?
For conducting also Mr. A.W. Amas have personal difficulty today, lordship. So matter.
2023 matter. Okay, your name, please.
S.A. Borgoya, lordship.
Yes, about petition adjourned. Yes, next.
May please, your lordship. I seek your lordship permission, my lord, to connect an IA, my lord. Allow me right on.
Listening. Listening, please.
May I please, lordship, I beg to mention item number 55, my lord.
55.
Maybe
yes.
taken up after summer vacation, my lord. 55.
Matter of which year? 19.
19, my lord.
Sorry, rejected.
May I
Yes,
please, your
next.
lordship, I beg to item number 22, lordship.
Item 22.
22,
Yes,
lordship. We need to file a linked evidence
Sorry.
document, lordship.
item 22.
22. It's a matter of 22.
Okay,
22.
adjournment. SK Nargi is adjourned. Yes, next
May I
item.
please, your lordship, I beg to mention item number 27, my lord.
27.
Kindly pass out this for the,
Your name, please.
my lord,
Your name.
M. Hawk.
M. Hawk petition adjourned. Yes,
May it please, your lordship, I beg to mention item number 23.
23.
Council for the petition of out of
Your name?
as a Samim.
S.
Zay Samim.
S. Samir adjourned. Yes, madam.
May I please, your
Yes,
lordship,
ma'am.
item number 57,
57 years.
I have filed additional affidavit as well as.
57 additional affidavit. You want to call for it?
Yes.
Yes,
May I
yes,
please, your lordship, I beg to mention for item number 10,
10, yes.
due to personal difficulty of my senior, matter may be adjourned for you.
Item 10.
10.
Your name?
You, Hazarika.
You Hazarika petition adjourned. Yes. talk for it.
Item 1 for motion.
Report of the SP has been produced. Land Council Home Department seeks for adjournment. Yes, so what is the report? Where are the report? What does it say, Mr. Sharma? Is it same person or different person?
Same person. lordship.
Same person.
Yes, lordship.
So if 66 is the father, then same person, then I think the petition have proved the case.
Yes, lordship.
Hmm?
Yes, lordship.
What do you do? We finish it here or we send it back?
Lordship.
Send it back.
Yes,
Why?
lordship. Let him.
No, what
the-
further
all
to be
documents-
determined?
Let all the documents may be placed before the tribunal. lordship.
No, no, what,
Which document?
what further to
On
be
the basis
determined?
of, on the basis of this instruction, lordship.
This report also be placed before the.
Yes, lordship.
May I submit, lordship? Petitioner himself has casted vote. His name appeared along with his father in the year 1966. 66 onwards till 2018, lordship. He had submitted voters
66, where is the 66? photo?
66 page 68, lordship. His name appeared there. Village Sastarghat, part 2.
Who is he?
Habibullah Sheikh.
Habibullah Sheikh.
Yes, lordship.
Yes,
Everything is matching, lordship, no, otherwise.
if he himself existed in 66, unless this voters list itself is a fake voters list, what further more to be proved?
Yes, lordship.
And one small point, lordship, may I just submit?
Lordship, why I am asking my friend that it may be so that the tribunal also knows that this is one more method they can use to verify when these cases are filed. Because Lordship has taken up.
No, no,
the
we'll,
exercise by calling up-
we will observe it, ask the tribunal to be provided a copy of our order circulated. Because if that is the only purpose,
That's the
then
only
let the order be circulated that this aspect has to be looked into by the tribunal.
This exercise, even it could have been done by the tribunal also, and they could have taken the stand there.
Finish it here only. Heard MSD Ghosh, land counsel for the petitioner, also heard Mr. G Sharma or A Verma?
His name is.
Mr. G Sharma, land counsel for the Home Department of the Government of Assam. The petitioner Habibullah Sheikh had been referred to the Foreigners Tribunal number,
Number 1, Dhubri Lordship,
page number
page number Lordship 17.
17, had been referred to the Foreigners Tribunal number 1, Dhubri, for rendering an opinion as to whether he is a foreigner within the meaning of Foreigners Act 1946, resulting in registration of FT case number 5334/D/2011. The tribunal rendered an opinion dated 22/8/2019 declaring the petitioner to be a foreigner. Being aggrieved, this writ petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of 1966 of village Sattar Ghat Park 2, Moza Patamari in the Dhubri district, which contains the name of Saritullah Sheikh, son of Milan Sheikh at serial 95, showing his age to be 50 years, and that of Habibullah Sheikh, son of Saritullah, at serial 101, showing his age to be 21. The petitioner claims that Habibullah Sheikh of the 1966 voters list of village Sattar Ghat Park 2 is the petitioner himself, and Saritullah Sheikh is his father. Both are noticed to be residing in the same house number 37, but however, for giving an opportunity to the respondents as to whether Habibullah Sheikh, son of Saritullah, father of Habibullah Sheikh at serial 101, and Saritullah Sheikh of serial 95 are one in the same person. The Superintendent of Police has submitted accordingly. A report was called for by the order dated 9/5/2023. Accordingly, the Superintendent of Police border had submitted a report dated 23/5/2023 before the court, which clearly mentions that Saritullah, father of Habibullah Sheikh at serial 101 of the voters list of 1966 of village so-and-so, and Saritullah Sheikh at serial 95 are one and the same person. The report also states that Habibullah Sheikh, son of Saritullah of the 1966 voters list, and Habibullah Sheikh, the writ petitioner proceeding before the court, are also one and the same person. As the name of the petitioner proceedee also appears in the voters list of 1966 of village so-and-so, it can be concluded that he is not a foreigner within the meaning of Foreigners Act 1946, read conjointly with Section 6A of the Citizenship Act 1955. Accordingly, Habibullah Sheikh, the writ petitioner, is declared to be a person who is deemed to be a citizen of India under Section 664(2) of the Citizenship Act of 1955. The exercise undertaken by the writ court in calling for a report from the Superintendent of Police border as to whether Habibullah Sheikh, the writ petitioner proceedee, and Habibullah Sheikh, son of Saritullah of the 1966 voters list are one and the same person, in our view, also could have been taken by the tribunal itself with due application of mind on the issue involved. Full stop. Once a proceedee claims that his name appears in a voters list of 1966 or prior, it is for the tribunal to undertake an exercise to identify as to whether the person referred in the voters list and the proceedee before the tribunal are one and the same person, rather than venturing into any other aspects of the matter. This order be circulated amongst all the tribunals to henceforth follow the procedure that if a given proceedee claims that he himself is his or herself, that his or her name appears in a voters list of 1966 or prior of any place, the endeavor to be made is to find out whether the person in the voters list as claimed and the proceeding before the tribunal are one and the same person. And only when the report may come that they are not one and the same person, the mass aspects may be proceeded in any other, the matter may be proceeded on any other aspect. This order be circulated amongst the tribunal.
Copy of this order.
Sorry, already ordered, Mr. G. Sharma. Something more?
Only 1.70 as well, 66 and 70. If the persons. who is the
So
president.
66 and 70, okay.
Did you-
60, only 70 description to the vote. Name appears as serial number so and so, only 70 voters list.
did-
A copy of the report, capital report.
Item two.
Item 2 is
Yeah.
Smriti Irani Das. So
Yeah.
we've taken note that none appeared for the video.
Because I'm for the.
You are appearing? Okay,
Yes,
fine. Who is the father of Smriti Irani?
The petitioner produced the voter list of father's sale date lordship before the tribunal, but it was produced in original. She could not, any of the, she exhibited A, B, C, D, A, but any of the documents she could not prove before the tribunal.
Sorry,
So-
could not follow you. What are you trying to say?
Lordship,
You said voters list, then you said sale
No, no,
list, then
no,
you
she
said could not
voted-
produce.
no,
Mane,
lordship,
what
lordship,
exactly you were
she
trying to say?
produced, she produced a sale date of her
Sale,
father.
sale deed in respect of a land purchased by her father.
Yes, lordship.
Which page is it?
And
Which
it-
page you find that sale deed?
It is at. It was a page 28. lordship.
Page 28,
Yeah.
okay.
That is translated copy.
Who is the father? Pratul Das.
Yes, lordship.
Pratul Das,
Pratul Chandra Das,
he is the father.
father.
He
Uh,
purchased a plot of land in
he
the
along
year
with his-
1968.
He along with his brother, Prachi.
Okay, very well. Huh. In which place? Sibsagar.
Sipsagar.
Very well. Now, which document will show that Pratul Chandra Das, son of Prasanna Kumar Das, is the father of the petitioner? And your address is little defective, resident under police station Sonari. Acha, village Tiok. Fine.
The
Which
first,
document will show
Ma-
that Pratul Das of Tiok village is the father?
page 40, lordship, the
40.
school certificate, where her father's name is reflected.
Was the school certificate proved in evidence?
That's.
Did the headmaster come forward?
No, lordship.
Let's do one thing, let's call for the school records. Again, sending back, it's ultimately what we find the tendency of the proceedings are multiplying for nothing. So if the school records are authentic, acceptable, we'll take a call here only. Otherwise, we'll send back. The education department through the district elementary education, is a high school or what school?
Page 40.
High school, right? To the inspector of schools, Sibsagar, to produce the admission register in original of Tiok
ME school.
or ME school, literally DEO, district elementary of Tiok ME school for examination of the court. A copy of the order be made available to MSB MS Court, Land Council for the Education Department for doing the needful. Police
Okay.
Council.
Item three.
Application to produce admission letters. Affidavit file कोई सा
Yes, ma'am.
My pleasure, lordship. Next that explanation was short for
Sorry?
regarding the
Petitioner relies upon a sale deed which Syed Mia son of Senator purchased or a the board of nobody done that. Yes, what is the evidence that Nayagaon Syed Ali later on went to Ambari?
In this regard, my lord, I want to file a affidavit, my lord. Client
File
will-
it.
No, I want to file, my lord, not file, my lord.
No, file it.
File it.
But why you have not filed?
My lord.
We have given you
Next.
sufficient time to file it. Why didn't you file it?
Yes, my lord, my lord, I want to take a signature of the client, my lord. In the
No, you take your signature. No one is preventing you.
Yeah.
These are cannot be a reason to not to file.
The 1 week time may be given in the meantime, I want to file.
And other day it is,
Yes.
we have noticed one aspect
Yes.
that maximum pendency is these foreign tribunal matters.
Yes.
So we want to be a little strict on it. No adjournment on just on the sake of asking. If you have, produce it. If you don't have, you face a consequence.
I want to put this, my lord.
Day after tomorrow. File it if you want to file, otherwise you are out. See, we have noticed one thing, whenever we are granting you time in a liberal manner to
Yes.
produce something more, when you don't have materials, the tendency is to repeatedly go on adjourning the matters.
Already.
Whenever the matter is good, you have material, you are too enthusiastic to argue with. Your approach should be an even approach. Not that a bad matter we go on adjourning and a good matter, yes, we want the order right now.
Bad matter, my lord. It's not a bad matter, my lord, it's a good matter.
It's definitely a bad matter as long as you don't produce the evidence that there is shifting.
Communicate with client, my lord, if they will come.
Do it, whatever is necessary. No one is stopping you. But
Then, my lord, I
please
will
go
file.
ahead.
Immediately I will.
Time can't be, you can't put the proceedings to a halt by just claiming that I am contacting my client.
Yes.
Friday.
Writing.
The affidavit sought to be filed by the petitioner as per the order of 7/6/2023 be filed on or before. Next Monday, okay, next Monday.
Published.
Giving 1 week,
26.
no time shall be
Oh, yes.
granted.
Published.
Item 4.
My lord, in this case, my lord, we have got the.
Information cases or not.
My lord, here in this case, my lord, we got the upline and downline voter list, my lord. We will,
You
we are
got it?
preparing, yes, my lord, we got it, my lord, we will file within 2 days, my lord, file every.
Mr. E.R. Sigdar Land Council petitioner states that the upline and downline voters list of villages, what are the two villages?
My lord, Bhatnabaiti Chor and
Patna, Patir Chor and
Bohoti and C.
Pohodi and C are available to the petitioner, and the same would be brought on record by means of an affidavit. Pray aloud, this conference.
Item 5.
Sorry, Education produce origin admission register of 110 Gurubanta.
Okay. But they are providing us only the results sheet or chip. Result sheet and one
See,
affidavit.
we are not examining whether the person has passed the exam or not.
Okay.
We want to know who is the father.
No chip.
Produce it. I stated that instead of the admission register in original, some result sheet had been provided to MSS Land Council Education Department. The education department is directed to do a needful of making available the admission registered in original of the school concerned. Or else DO personal appearance, tell him.
Item 6,
Yes, item 6
Also
will
education
appear.
matter, Lordship.
This
This is also education register has to. put
MD
25
may
days.
be education.
But
Where is Madam Kaur
we-
gone?
PDK is not available due to traffic jam, Lordship, for the time being
Okay.
possibility.
Time being.
item 7,
7.
May I please, your lordship.
Yeah, sit there. First time
Well,
coming.
well,
Who is the father of Manoj?
Father, my lord, uh, Abdus Rahman, my lord. My lord, I am starting from my grandfather, my lord. 66 voter list contains the name of grandfather.
Page number.
Page 23, my lord. Vernacular 24. Father's, grandfather's is Nasimuddin.
Nasimuddin is the grandfather.
Village Borbita.
Village is Borbita.
Then my lord 70
Okay.
also same.
No,
Then-
let me, who is the father now?
Father, my lord, in 89 voter list, lord, you will find at page 27.
Page 20.
Amjad Hussain, son of Nasimuddin, in same village.
Just a minute. Amjad Hussain is the father.
Father,
And which document will show Amjad Hussain is the father?
my lord, lord, you will find in the next voter list, 1997, page 29.
Why name of Amjad was not there?
My lord,
1985 and 89, his name
89.
comes in, now 40 years.
40 years.
So why his name was not there in
My lord, the
1970?
voter list are not furnished, but there are
Uh,
other land documents, my lord.
Did
I
the
mean,
name of Amjad appear in 1977?
Yes, my lord. My lord, there are other land documents.
So
the
where
only-
is 1977? You said
That
yes,
has not been furnished to us, my lord.
you are not provided. No, you said one yes, that's why you wanted to see.
My lord,
Anyway,
there are
which
some
doc-
of the copy.
Which document will show Amjad is the father?
My lord. Amjad is the father, lords will find at page 29.
29.
The petitioner is voter with his father.
Well,
Amjad Hussain at serial number 182.
Yes,
Moinul Haq 180.
Mr. Sharma, notice interim?
Yes.
I heard Mr. Yashik Lal and concept for this. Okay. Likhi lobo. It is claimed that Muhammad Nasimuddin, son of Mahmud Ali, at serial 40 of the voters list of 1966 of village Borbita, is the grandfather of the petitioner, whereas Amjad Hussain, son of Nasimuddin, of the 1989 voters list of village Borbita, is the father of the petitioner. Petitioner also relies upon the voters list of 19, which year is it?
1997. my lord.
Of 1997 of village Borbita, which contains the name of Moinul Haq, son of Amjad, and it is claimed that Moinul Haq of the 1997 voters list itself is the red petitioner. Prime Minister made in the call for the records.
Deep love.
item 8,
May I please, your lord.
Yes, Mr. AHMR,
My lord, page 18, my lord.
page number 15,
18, my lord, total list of 1960.
page number 15,
18, my lord, 18.
Devanir Alga, Somir Mirda, he is the father.
Yes, my lord, Quran Mirza, my lord.
No,
Then your-
Quran Mirda,
Quran.
Quran Mirda is the father, Devanir Alga.
Then, my lord, your lordship will find page 20, my lord. Total list of 1966.
Sorry,
Page 20, my lord.
20, yes.
Total list of 1966, my lord.
No, that is okay. Which document will show Mujibur is the son of Quran?
My lord, what happened, my lord? After 1970, my lord, in the total list of 1960 and 66 and 70, name of the petitioner fathers and mother appeared, my lord. Then after 1970, my lord, the mother of the petitioner shifted to another village along with her.
You proved the shifting.
My-
You proved the shifting. The petitioner may produce any relevant material that the father of the petitioner, whose name is claimed to have been appearing in the voters list of 1966 and 1970 of village Devaner Alga had later on shifted to village Haldia Kho.
Haldia Pata.
Haldia Kho or Haldia Pathar
Another village.
in the Borpeta district. Agoto Likibo, South Salmara Mankacha district.
My lord, mother shifted.
Sorry?
Father remained in the earlier village, my lord. Mother shifted to Haldia Patar, my lord.
Father remained there.
Yes, my lord. And
So
he
where is
died,
the name of the father in the subsequent list?
he died after 1970, my lord.
Okay, he died. After that, the mother shifted to.
Yes, my lord. And
Possible.
what happened, my lord? After
You bring in some material. Means after death of the father, mother shifted to her paternal village.
Yes, my lord. But another thing is that, my lord, after shifting, my lord, her name was recorded as Moijan Bibi, but in the voter list of 1966 and 76, her name was recorded as Kaitori Bibi. That is why the, my lord,
The petitioner to also produce relevant material that the Maidan Bibi of the 66 voters list.
Kaitori Bibi of 60.
What Bibi?
Kaitori Bibi.
Khaidul Bibi of the 66 voters list was later on came to be known as Maidan Bibi.
Maijan Bibi.
And that they are the same person.
Published.
Item 9.
Mother of the petition of Boni, you come here, mother will have only 76, later on. No, I believe. Mr. AMHR Chaudhary. Who shifted? Mother shifted.
Mother shifted
And father died in after 1970.
after 1970. my lord.
It only mother's name appeared in 70 voters list.
66 and 70.
60 and 70. Later on shifted after death of the father. Yes, item 9, Mujibur Rahman,
My lord,
page number.
Lordship, page 58,
Sorry.
page 58, name of the father recorded in the voters list of 1965. And his father name is Hamed Ali Elias Nisu Ali. In the voters list of 1965 and 70, his name recorded as Nichu Ali. And from 1970 onward, it is Hamed Ali was recorded. So Lordship,
The petitioner to produce any relevant material that Nesu Ali of the 1970 voters list and Hamed Ali of the subsequent voters list are one and the same person.
Lordship,
Mr. L.R. Mojumdar, we go only by materials on record.
Lordship,
We don't go by any statements.
Lordship, another thing, Lordship, he also exhibited a sale deed.
May have. First, you settle the issue that they are the same person. How do you know Nesu and other one is a different person or same?
There is no change of resident, Lordship. Father's name all along, his Nisu Ali's father's
No,
name
we
all along.
understand.
remains
How do
same.
you know Nesu Ali and the other person, they are the same person or different person? Something has to be there.
From the Lordship, there is no such document as such. Only
You can prove
statement is
by,
there.
you use your legal acumen, prove by any material which you feel you have. Otherwise, we can't go merely by statements. In one case, we go by statement, next case also somebody will say that I am stating this.
Lordship, otherwise also, his.
Otherwise, we dismiss the matter.
Lordship, one thing I submit, land document pertaining to the year 64, Lordship. So that can be.
You
like-
show Nesu Ali and Hamed Ali as the same person. First, you do undertake that responsibility. Then we look further.
Lordship, there is
The petitioner refuses to produce any material
No.
that Nesu Ali and Hamed Ali are same, dismissed for not providing relevant material. Detail order to follow later. Yes, next item. We're dismissing it then if you don't want to produce. Want to produce?
not.
Please produce.
Item 11 for admission.
Try to make it easy for the litigants. You try to make it more and more difficult for yourself. Yes.
May I please? My lord, here I have filed an additional affidavit.
Additional affidavit.
Yes.
Now,
Page
Tasmina Begum.
51.
Peter Rely voter 66 of Village Sivapur in the Nova.
Here, my lord, we are relying to the
Can
66
change
voter
the-
list and 70
Just
voter
like
list
the
of our
things that name
grandfather.
of A. Ali Sana. What material you produced at A. Ali of 66 and Mokram of 70, same person?
Your lordship kindly peruse affidavit page, my lord, 51.
Page 51.
Here, my lord, our grandfather's name is Mokrobal. And I have stated in my additional affidavit, my lord.
No, not translated copy of the relevant portion of the voters list of 66.
Yes.
Yes.
In house number 14, my grandfather name appear. A. Ali is the paternal grandfather. His name, my lord, he inadvertently out of mistake, my lord, his voter list exhibited.
Sorry. Acha.
In
The
house-
complete voters list is Ayub Ali, great grandfather, and Mokrab Ali, grandfather.
Yes, paternal grandfather.
But mistakenly, Ayub Ali was called to be the grandfather.
Yes.
Very good. Yes, Mr.
And 70 voter list also,
Hmm.
that I have annexed in your lordship will come page 54.
50.
Same house number,
Okay, no, accept it. So Mokrab Ali is the grandfather.
grandfather.
Now, who is the father?
Father, my lord, page 56, my lord.
Nuruddin.
19 Nuruddin
Nuruddin is the father.
of Mokrobal, son of Mokrobal.
Mokrob grandfather. Ayub great grandfather.
And now, page 58, my lord,
So just a minute.
same village.
Just a minute. We understand. Ayub Ali is the son of Ishra.
Ishra,
Mokrab also son of Ishra.
Ishra. Paternal
So
grandfather.
how Ayub can be the great grandfather?
No, paternal grandfather,
Paternal?
grandfather. My grandfather's brother.
Okay, okay, fine. So Mokrab, 31, well. Nuruddin son. of-
Page 58, my lord.
Just a minute, a little slow. What happened to Mokrab after 1970?
1970, he expired after 1960. Thereafter, his name not appeared.
He died in 1970.
After 1970, exact date.
Where is the name of Nuruddin prior to 1997?
1997, 86 voter list I have, my lord, exhibited.
Page number.
That is, my lord, in record, your lordship, kindly peruse, my lord. 85 voter list, page 39 of the LCR.
Page 39 is
There are
something different.
two paginations, our first, second time, and second pagination.
दूसरा page number क्या था ये? Mr. G. Sharma, why the record contains two different page numbers always? One series of page numbers, say up to 1 to 30 something or 40 something. Then another series, you start from 1 to something else.
They are, in fact,
So resultant situation is there are two page numbers containing two different, same page number containing two different documents. Why it can be converted to one page number when you make it? Page number 90, 30,
39.
39. Just take up the records. In other cases also we found the same thing. Nuruddin.
85 voter list,
Moharab Ali.
same village.
Okay.
Now, so what petitioner is concerned,
Okay. And which document will show petitioner is the son of
petition number
Nuruddin?
2, my lord, page 58 of the affidavit of lordship can see.
Page 58.
Petitioner number 2, his name appear with his father, Nuruddin.
Petitioner number
2.
What about one?
One, she married off, her Tabin Nama is the heaven,
One is the daughter of Nuruddin
daughter of Nuruddin.
and petitioner number
Who
2.
is the son of
Why two petitioners in one writ petition?
common order. Two
Why did you
proceedings are
pass a
initially there.
Why did you pass a common order?
Initially, two
I think
proceedings.
the references ought to be individual reference.
Yes, yes, Lord.
And who, petitioner number two, name of petitioner number two?
Two is Jamaluddin,
Jamaluddin.
Jamaluddin. Third name, my lord. One is
Two.
Nuruddin, then
Yes.
third Jamaluddin.
And
Page-
any voters list prior to 2018,
2000 prior to 2000,
97 and 18?
my lord, 2005. I have NH voter list of 2005,
Page number,
page number 40, my lord, of the LCR.
page number 4.
That was exhibited. Jamaluddin name appear in 2005 voter.
Mr. Sharma,
Ma'am.
will you send it back? Consistently, it is there, maybe with small gaps here and there. You don't know. Third, Mr. A, I wouldn't learn counsel for the petitioner. And petitioner number one is?
One is daughter, my lord. Page 60, I have annexed a cabin number.
And we'll ask this tribunal to pass separate orders against the two persons. Let both go back. The petitioner MUSTT Jasmina Begum
And Jamaluddin.
as petitioner number
One.
and then petitioner number one Jasmina Begum and petitioner number two
Jamaluddin.
Jamaluddin had been referred to the foreigners tribunal number
That is separate.
number 7 Nogao,
No.
resulting in registration of FTL case number 230/15 in respect of Jasmine Begum and 234/2015 in respect of Muhammad Jamaluddin. It is Jasmine Begum, then why Tasmina Begum is before the court?
This is written, Jasmina is her correct name.
Then you should not be worried. You are not a foreigner. Jasmina Begum is a foreigner as per the tribunal. Why then Tasmina is before the
She
court?
appeared and filed the written statement. Received
Again, the
notice.
same problem. First, you verify the identity of the person, then proceed.
That was not done.
To whom the notice was issued?
Doesn't petitioner.
Jasmina
Begum notice issued.
Where is the notice?
Notice maybe in the record.
Find out. Full stop. The notice served, notice served by the tribunal in FTL case number 230/2015 shows that it is addressed to MUSTT Jasmine Begum, whereas on the other hand, then it was served upon MUSTT Jasmina Begum.
Jasmina, it was written as Jasmina initially, subsequently it was corrected as Jasmine.
How can you correct it? No problem. Issue is to whom it was served.
Jasmina. Jasmina.
Full stop. In the circumstance, it is Tasmina Begum who appeared before the tribunal.
Jasmina. Jasmina.
Just don't go on creating a confusion. It is Tasmina Begum who appeared before the tribunal, but was proceeded before the tribunal as Jasmine Begum, Jasmina Begum. Jasmine Begum. Although the notice of service appears to have rendered an a correction without any notice, now making the name to be Tasmina Begum. Instead of creating all the confusion, it would have been a better approach for the tribunal to first verify who actually the proceedee is and to whom the notice was served, and thereafter proceed in the matter. In the circumstance, by the NI, in the opinion dated 22/1/2017, the tribunal had rendered an opinion that MUSTT Jasmine Begum is a foreigner, but by examining the materials and documents produced by Tasmina Begum, in the circumstance, the opinion of the tribunal in FTL case 230/26/15 is set aside. FTL 230/15 is remanded back to the tribunal to first verify as to who actually is the proceedee, that is whether MUSTT Jasmine Begum or it is MUSTT Tasmina Begum, and thereafter proceed in the matter. If the tribunal is of the view that the proceeding is required to be initiated against Tasmina Begum, the records it be accordingly proceeded by allowing Tasmina Begum to produce any relevant material which may prove that she is not a foreigner. And if the proceeding is to be initiated against Jasmine Begum, Tasmina Begum may be discharged from the present proceeding and appropriate notices be served upon Jasmine Begum, and thereafter proceed in the matter. If the tribunal is also of the view that Tasmina Begum is also required to be proceeded against, then appropriate references may be initiated against Tasmina Begum and the proceedings be initiated against her. As regards FTL case number 234/2015, the petitioner number 2, Jamaluddin, relies upon the voters list of 1966 of village Shipur, police station Murajhar, Moja Kopasbari in the Nagaon district, which contains the name of Mokrab Ali, son of Ishraq, at serial 45. Name of Mokrab Ali also appears in the voters list of 1970 of village Shipur, at serial 45. The voters list of 1985
is 39.
of village Shipur contains a name of Nuruddin, son of Moharab Ali, at serial 389, and it is claimed that Nuruddin is the father of the petitioner. Thereupon, reliance is placed upon the voters list of 2005 of village Shipur, which contains the name of Jamaluddin, son of Nuruddin, at serial 941. But this lady is Tasmina or Jasmina?
Jasmina.
Jasmina.
Jasmina. I will next her.
Then why did you take the stand that she is Tasmina?
No, Jasmina, my lord. She has filed a written statement with Jasmina.
No. Initially, why did you led us to pass that order claiming that you are Tasmina?
Jasmina, I tried to, my lord. But your rushing is continuing. Therefore,
No, your first statement we heard that you are Tasmina.
No, Jasmina. All along, I am claiming Jasmina. And notice is tribunal name, written the name as Jasmine.
Then what is this name in the writ petition? Jasmina or Tasmina?
Jasmina.
Then what-
Jasmina.
কি নিচিনা দেখিছ all confusion এইটো দেখাত কি নালাগে আবার তুমি কাটি দিও হ্যাঁ কি বলো নুরুদ্দিন কলো নাকি 2005 reference is also made to the আগৰ টাচমেনা খিনি কাটি থৈ দিয়ক reference খিনি থাকক petition number 2 পৰা থাকক voters list is voters list of 1997 of village Shivpur is also relied upon, which contains a name of Nuruddin, son of Bokrab at 315 and Jalaluddin, son of Nuruddin at 317. And it is claimed that Jalaluddin had been wrongly depicted, whether it ought to have been Jamaluddin.
Jamaluddin name is there in 2018. Jamaluddin. Page 58 of my affidavit. Jamaluddin with his father, his name there.
Then what you have written in page number 56.
56 Nuruddin and Jalaluddin, elder brother of the present petition.
The petitioner to file a detailed affidavit showing the family history of the petitioner, starting from Mokrawali of the 66 voters list to Jamaluddin, the writ petitioner. Write in one paragraph the entire thing so that we can write our facts correctly. You can't go on changing like this.
I can tell.
Every line.
Oblige.
And so. Tendency of English matter 70
19 or no, no, 20.
all the records for the figure 2232 where Aadhaar you do also check for the second 225 review half one. Able to figure out to is quite তাৰপিছত আমাৰ প্ৰতিশ্ৰুতি তেওঁ জীয়াব পৰা নাই আৰম্ভ কৰিব আছে Madam Verma, there's a huge pendency of matters of 2018 and 2019. 18 is 1300 something, 19 is 1900 something.
In the High Court, Lordship,
Sorry,
here in the High Court.
yes, in the High Court. So we'll put up a notice. 18, 19, absolutely no adjournments. Please take note of it and don't ask for it also. Unless, of course, somebody is seriously ill or there is some bereavement in immediate family, these are the only two grounds we may accept. Other than for dilly-dallying the matter, no adjournments.
Fresh matters may,
Sorry.
the fresh matters which are listed in motion now, they may be put on.
No,
notice and
the
kept, Lordship.
fresh matter will take it as it comes.
Yes.
Nothing like that, that
These
because of
may-
19 fresh matter will not
Lordship
take it up.
Find matters of 15 and 16. I don't know if Lordship has the list, but there are matters which are pending from 15 and 16.
15, 0,
16, Lordship.
1639.
So let us start from 16. because
That
we-
we'll see. You
we
don't have to, the management, you don't have to worry, but especially 18 and 19, don't ask any adjournment. And any adjournment without reason will entail a cost of 10,000 rupees straight away.
17, we don't have any pending.
17, 919. That is also quite high. So we'll put up a notice, if necessary, write in the notice also. Adjournment without any acceptable reason. Ah. Will entail a cost of 10,000 rupees. Unless the reason is something very immediate, that some extreme medical urgency of the council or some bereavement, etc. in the immediate family, not a distant family somewhere.
Lordship can even have the 16, 17 matters listed.
Take it as usual. So one notice will be coming up on this.
Hi, Lordship. Hi. Hi, Lordship.
The fixed number that you take you home, which you notice that no adjournment.
No adjournment.
In upper different.
Hi, hi, hi.
Spot at the beginning or in the end of the
Hi, Lordship.
no adjournment.
No adjournment will be permitted. How about
Open you could actually fix it. Serious medical.
কিন্তু আমি নেই করছি কোনো adjournment will be permitted দিয়ে লিখি তেওঁলোকে সাবমিট করে করে
Proper.
লোকন
No.
no adjournment for adjournment so it's hi hi hi
He was.
hi Lordship.
ঠিক আছে
18 minutes 17 towards Lordship. It is 17 18 I'm daily basis rotation wise no adjournment not to clearly.
Yes, Madam Ghosh. Raichand Das.
Yes, Raichand expired. So today I have filed the.
Raichand Das. It stated that the petitioner Raichand had
This
died during
week
the pendency of the writ petition and application for substitution of the legal heirs
Yes,
had
I
been
filed
filed,
today.
list along with the application.
If possible before vacation, because already I had filed it.
Take it over to court master.
7 June.
You bring it tomorrow, we'll take it up.
Yes, 27. Deep
Noor
vote.
Bhanu, yes.
Item 13.
Noor Bhanu.
My lord, 65 brutal list lodgement.
Page number
Page 30.
30.
Yes, my lord. Asha Kali Mia is the father. Aimona Khatun is mother of village Anandapur.
Ashak Ali Mia father.
Father,
Aimona mother.
mother. Then my lord, the other brutal list, but I want to relate.
Village is Anandapur,
Yes, my lord.
Moza Bhawanipur. Borpeta, okay.
My lord,
So now which document
Father-
will show Noor Bhanu is the daughter of
my lord, no
Asahak?
specific documents except the overall documents, but here brother was examined. And brother is
Any-
brother with parents, my lord.
Any voters list of either Asahak or Aimona along with the brother,
Yes, my lord.
Page
At
number?
Page 42, my lord.
page 42.
Messer Ali, brother, my lord. In same village, and Messer Ali was examined as DW2.
Messer is the brother,
Yes, my lord.
Aimona Asahak. Yes, Mr. Sharma, what do you say? Hmm? Married daddy has no other way to prove the case. You cross-examine the brother if he is wrong, or you make a verification also. Verification plus cross-examination. Heard Mr. A. Sigdal and counsel for the petitioner also heard Mr. G. Sharma. The petitioner Noor Bhanu had been referred to the foreigners tribunal number. Where is the judgment, Mr. Sigdal?
My lord, at page 65.
65. I've been referred to the Foreigners Tribunal number 10, Borpeta, for rendering an opinion as to whether she is a foreigner within the meaning, with a foreigner under the Foreigners Act 1946, resulting in registration of FTTS number 458/2017. The tribunal rendered an opinion dated 26/6/2018, declaring her to be a foreigner. Being aggrieved, this writ petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of 1965 of village Anandapur, police station Borpeta, in the present Borpeta district, which contains the name of Asahak Ali Mia, son of Bahizuddin, at serial 339, and Aimona Khatun, wife of Asahak Ali, at serial 340, where both are residing in the same house number 83. Reliance is also placed upon the voters list of 1970 of village Anandapur, containing the name of Asahak Ali Mia, at serial 363. Further reliance is placed upon the voters list of
2010
Mhm.
is 42 million.
Mm.
There are other voter list of.
No, that must say on the voter list of 2010
Yeah.
of village Anandapur, containing the name of Asahak Ali, son of Bahizuddin, at serial 481. Aimona Khatun, wife of Asahak Ali, at 482, and Meser Ali, son of Asahak Ali, at serial 485. It is claimed that Asahak Ali is the father, Aimona Khatun is the mother, and Meser Ali is the brother of the petitioner. As the name of Meser Ali also appears along with Asahak Ali and Aimona in the voters list of 2010 of the same voters list of village Anandapur, where the name of Asahak Ali and Aimona also appeared in the voters list of 1965 of village Aimonapur, of Anandapur, comma. The Meser Ali had deposed before the tribunal as DW
Two.
Stating that the petitioner Nur Bhanu is his sister, meaning thereby daughter of Asahak Ali. In view of the above, remanded back to enable the Home Department or the Government of Assam to make their own inquiry as to whether Meser Ali is actually the brother of the petitioner Nur Bhanu, and submit report before the tribunal, as well as to enable the Home Department to cross-examine DW to Meser Ali as may be advised. Upon doing the needful, a reason order be passed.
Item 14,
Some time also.
Adjourned on the prayer, Mr. A. Ali, for producing the voters list in original of the village consent. But Mr. Ali, we look 18 matter.
Yes, Your Lordship.
Slowly we'll be a little more strict in giving
Yes,
further
yes, Your
time.
Lordship.
Yes, 15. Yes, Madam Ghosh, Lokhi Das, who is the father?
Father is Lal Mohan Das.
Page number
Refugee certificate, page number 33, Lordship.
33, refugee certificate. He is indicated to be a person of which village?
Nis Dimoria,
Nice de Moria. Fine. Police station Guwahati.
Guwahati at that time. Now it's Khetri. Now it's Khetri.
Nice de
The father of the petitioner. Lordship. Father, mother, along with uncle.
Who had issued this certificate?
MP, some president. Assam Refugee Federation.
What is the date? 1963. What is a federation?
At that time, this federation was being made. President was one MP D.N. Sharma. Apart from this, she wrote.
From where can we look at the records of this refugee federation? Is it still surviving?
No, it's not surviving lordship.
No, no,
Because we
why
tried-
we are putting this question? His lordship is also asking that this is not a government organization.
Yes, lordship.
Suppose we still accept it,
Yes, lordship.
in spite of being not a government organization. Because we are more concerned with the factual contents contained in this certificate.
Yes, lordship.
But now if that record is not available, the organization does not exist anymore, then the certificate has no value. What is a certificate? Depicting
Yes,
some information contained in some public record.
yes, lordship.
If the record doesn't exist anymore, the organization issuing the certificate does not exist anymore, the value of that certificate is
Yes,
no more acceptable in law. Any other document of Lal Mohan?
no, lordship. This is the only document.
What did Lal Mohan do?
Due to religious persecution, they have migrated.
No, no,
from there.
we are not on the reason, we are not on migration. What did Lal Mohan do here?
He resided within the jurisdiction of that area only.
Understand? No, what did he do in his life?
He was a daily wage earner. Apart from that, only one document, lordship, no other document.
Understand? No, no. In life, what did he do?
He was a daily wage earner. As
He-
per my instruction from the
Daily
client.
wage earner.
Yes, lordship.
Do you have the original of this?
It's in the record, lordship.
Hmm?
It's in the record.
Page number?
Just
No, I was seeing it. Documents exceeding 30 years old, presumption of to exist. Only way, madam,
Yes,
till now what we can conceive, there must be a provision somewhere in the Evidence Act
yes,
of a document exceeding 30 being 30
yes,
years
section
old.
9. I am not
Can you
wrong.
take the help of that provision? Explore it.
Yes, lordship. There is judgment of our honorable high court only, one judgment. also.
Otherwise, we see very difficult,
Yes, lordship.
because certificate you cannot, because the moment the organization issuing the certificate does not exist,
Yes,
the records does not exist, certificate has no value.
yes, lordship.
Hmm.
Section 90, this. I can bring in, if it's tomorrow, or not tomorrow, day after tomorrow, I can just.
We
bring in-
adjourning it, you formulate your legal argument,
yes,
how you can,
Yes,
otherwise,
yes, lordship.
as you were saying, Lal Mohan is a labor, a daily wage laborer, he must not be, his name must not have been recorded anyway. Did he have any ration card?
No, lordship.
He did not eat or what?
Hmm?
He did not avail the benefit of a fair price shop. Daily wage labor must have taken. Do we have the ration card?
When this NFSA Act came in, lordship.
NFSC is very
Yes,
recent.
so they have seized all earlier cards, they have taken the earlier cards and they have issued the new cards in the name of the elderly lady in that particular family.
Who is the elderly lady?
So that I need to.
Lal
But
Mohan is,
but Lal Mohan.
Lal
and
Mohan is not a
I-
definitely
That I
elderly.
have mentioned.
Who appears for the government otherwise? You appear. Are your ration cards that have been issued earlier, do you still maintain those records?
Lordship, it must be there, but I have to.
We are not interested with the answer must be there. Do you still maintain it or you do not maintain it?
Lordship, I'll have to obtain
You are
instructions on it.
Produce, get the information. And if yes, around the corresponding period, was any ration card issued to Lalmohan?
Lordship.
Maybe that will be a corroborating material for
Yes,
this document. Your name, madam?
U Sharma.
MS U Sharma, Learned Counsel for the
Government, junior, I'm the junior governor.
Vinegar for whom do you appear?
For the deputy commissioner, Lordship.
For the Deputy Commissioner Kamrup. This will be Kamrup Metro?
Kamrup Metro, Lordship. respondent
Kamrup
6.
Metro to inquire from the authorities and provide the information as to whether the records of the ration cards that were issued around the period 1963 and later are still available with the authorities. And if yes, whether any ration card was issued in the name of Lal Mohan Das, son of Kailas Das, in respect of village Niz Dimoria. Take a order. Order be provided, a copy of this order provided at MS U Sharma, Learned Counsel, for doing the needful. Ask somebody in the Deputy Commissioner,
Lordship.
do you still retain those records? And if yes, whether anything was issued in the name of
In the
Lal
name
Mohan
of-
Das. And you also find out.
Yes, I will also.
The petitioner to also explore in the office of the regarding the existence of the aforesaid information. This council.
28th July. Item 16.
20. How to convert it?
July.
Madam Sharma. Lordship is saying it may be in the office of the Deputy Director of Civil Supplies. Normally, that office is located in the same building of the Deputy Commissioner, but maybe a different establishment also. If it's a different establishment, I think you'll have to ask from the supply department.
It's Lordship may reflect it in the order. It will make it easier for her to get, because DC may send it. Lordship. Deputy Director of Civil Supplies. I've just taken note of it.
Verma,
Yes, Lordship.
the views we form tentatively based on unsubstantiated information, we cannot record it in our order. This is only we are trying to help her by indicating that you may get it there also.
Lordship, the refugee certificate. At that point of time, Mohanlal Das was 36 years old. So definitely his name ought to have been there in some voters.
Because if you get some further material, that will corroborate this. And this document, apparently it appears to be a document more than 30 years old.
It is.
Mhm.
If it is
So then
a genuine one,
it
Lordship.
will be a complicated legal maneuver for you, try it out.
Other thing, there's no voters list, no, in Lucky Das's case. Not a single voters list, Lordship. If he came in 63, because.
Maybe he was a man who did not believe in democracy. A person who did not believe in democracy, so I don't want to vote, don't put my name in the voters list. But otherwise, she is raising a pertinent thing. Why voters list does not include his name, Lal Mohan?
He was 36 at that point, Lordship.
Hmm.
At least one voters list.
That instruction I have to,
Just,
I'll talk to the.
it's most unlikely that his name will not be there in the voters list. He must have taken-
66 may not be possible. They,
But later on also.
later maybe in 70.
Suppose
or
in-
something.
If it is there in 77 also, but
Yes,
of the same village, that will also show you
Yes,
something.
I'll tell her to or get all the documents, whatever.
Yes, next item.
Item 16.
May I please, your lordship?
Sorry for the, who is the father?
Grandfather's name appeared in the voters list of 1966,
Page
page
number.
41, lordship. Abbas Ali.
Abbas Ali.
Yes,
He is the
grandfather,
grandfather,
village Tenga Guri,
son of Tarif Sheikh.
Torif Sheikh.
This
Two brothers
is
together.
66.
Yes,
Village Tengaguri, Kosari Gaon,
yes, then 70.
Lahori
lordship.
Ghar. 70, page number,
Page number, lordship, 43.
page number 43. 43
Abbas.
Abbas, father,
No, grandfather.
grandfather.
Yes, lordship.
So now 85.
Then 85, lordship.
Salam is the father,
Yes, lordship. Salamuddin.
same, Tengaguri,
Yes, lordship.
Abbas, very well. Now, who is the petitioner?
Yes, petitioner
Sorry
is,
for the,
sorry,
yeah, which document will show? Sorry for-
49, lordship.
Page number
49, lordship.
49. Salam and Sorifuddin together,
Yes, lordship.
same village.
Same village, lordship. Tenga Guri. Kosari.
Sorifuddin is 19.
Kosari Gaon.
Yes, Mr. Sharma, what do you say? Examine it. Third, MSP Coast Land Council for the petitioner also heard. Petitioner Sorifuddin had been referred to the Foreigners Tribunal number 2 Morigao for rendering an opinion as to whether he is a foreigner under the Foreigners Act 1946,
Page 18, lordship.
resulting in registration of FT 27/70. The tribunal rendered an opinion dated 2/7/2018 declaring the petitioner to be a foreigner, being aggrieved the said petition is instituted in the writ proceeding. The petitioner relies upon the voters list of 1966 of village Tengaguri, Kosari Gaon, police station Lahori Ghat in the Nagaon district, which contains the name of Abbas Ali, son of Tarif Sheikh at serial 67, which information is also available in the voters list of 1970 of village Tengaguri, Kosari Gaon. Petitioner thereupon relies the petitioner also relies upon the voters list of 1985 of village Tengaguri, Kosari Gaon, containing the name of Abbas Ali, son of Arik Sheikh at 102 and Salamuddin, son of Abbas Ali at 104, both residing in same house number 10. It is claimed that Abbas Ali is the grandfather and Salamuddin is the father of the petitioner. To substantiate the same, reliance is placed on the voters list of 2005 of village Tengaguri, Kosari Gaon, containing the name of Salamuddin, son of Abbas at serial 151 and Sorifuddin, son of Salam Ali at 154, where both are residing in the same house number 158. Petitioner claims that Sorifuddin, son of Salam of the 2005 voters list of village Tengaguri, Kosari Gaon is the petitioner himself, and accordingly claims that a burden under section 9 of the Foreigners Act 1946 had been discharged. View of the above, remanded back to the tribunal to examine the voters list of 1966 of village Tengaguri, Kosari Gaon, containing the name of Abbas Ali, son of Tarif Sheikh at serial 69, which, where his name also appears, as well as voters list of 1970 as well as the voters list of 1985 of the same Tengaguri Gosarigaon, continuing Abbas Ali and Salamuddin together, as well as the voters list of 2005 of Tengaguri Gosarigaon, continuing the name of Salamuddin and Sorifuddin together. The respondents in the Home Department to make an inquiry and submit a report before the tribunal on the authenticity of the information as claimed in respect of the voters list of 1966, 1970, 1985, 2005 of village Tengaguri Gosarigaon, as well as on the fact claimed as to whether Sorifuddin son of Salam of the 2005 voters list of village Tengaguri Gosarigaon and the writ petitioner Sorifuddin are one and the same person. Upon doing the needful, reason order be passed.
Deeply like
Item 17.
Lordship, in this case, I couldn't. After the last occasion when it came up, after that, I talked to the client, Lordship,
Cancer patient.
cancer patient, Lordship.
What to do with this cancer patient?
Let me talk to him because the two options were given, three were given.
No, otherwise,
Yes.
because if you want to avail the state benefits,
Yes, Lordship.
they are very clear in this stand, they won't provide it to a foreigner. And once they do it, a lot of such claims will come in from all different sides. So either we hear this petition and declare the petitioner to be not to be a foreigner. If you have good overwhelming material, you can argue the matter.
Yes,
Then you can go for your treatment.
yes.
If you need more time to produce material, then we cannot declare so.
Yes, Lordship.
Then you will be without treatment. And we have to take a little more humanitarian approach. Consider the person is a cancer patient. How do you do? Go ahead.
What is this condition?
At present, medical documents I don't have.
You can go for your own medical treatment at your own expense. We cannot
Yes.
prevent that,
Yes,
but
yes,
we cannot request the state authorities.
Yes, Lordship.
Once their
That-
stand
that
is
I
very
understand.
specific, that we don't provide for subsidized treatment for foreigners. So although it doesn't sound very good,
yes, Lordship.
only option is
Detention.
if they take you in their custody, then they'll be bound to provide you with the treatment. But I don't know how far the person will like to
Yes.
have it that way.
In
It's-
that count only just.
So it's your call.
Yes, I just wanted to talk to him once, which I couldn't after the last occasion on.
Adjourn on the
15/6.
prayer of MSD Ghosh, Land Council for the petitioner without payment of the 10,000 rupees cost. Because otherwise you would have
Yes,
imposed the cost.
Lordship. Deeply.
Pending delay, it will be last idea, considering and adjourn to explore explore in what manner the petitioner intends to avail the medical treatment for his medical state for his cancer disease.
Deeply.
Otherwise, what possibly you can conceive? We can give you an immediate hearing if you want it today itself,
I can understand.
provided you are confident that you have the materials to prove your case.
I have only one document, only birth certificate and citizenship by birth. Apart from that, I don't have anything. He was brought up
Citizenship
like,
by birth may not be applicable to you. Under which provision?
today, actually, I just missed out the book. So otherwise, as per the section 3 of the Citizenship Act, citizenship by birth, who was
No,
born
that is
prior to
appli-
1/1.
No, that is
1986.
is not applicable to foreigners. But
May I read the provision, Lordship? I just
we
get
have
the
read
book.
it number of times.
Yes,
Is it
Lordship.
applicable?
Yes, Lordship.
Then who was your father?
Irrespective of the parents, whether they are foreigner or not.
Sorry, this
Yes.
is where you are wrong.
I'll just get it, Lordship. Today I'm not, I'm
No,
a
this is
bigger
where you were
person.
wrong. There are two exceptions. Number one,
Yes, I'll just read the provision.
because that's a dangerous argument.
We cannot, then citizenship by birth, Lordship will go then.
Citizenship by birth is not applicable to this category of people. Because you are covered by 6(4). Only non-6(4) people are covered by section 3.
May I read, Lordship?
You may read,
Yes, Lordship.
but
Except as
this
provided
argument was made by somebody else a couple of days back, so we are quite sure. Same
Yes.
argument was raised,
prior to one.
and we don't want the just reading of the provisions. We want the interpretation of the law.
Yes. Section
6(4),
6(4).
special provisions. So once you are covered by 6(4), will you be excluded from section 3 or you'll be also included in section 3? You'll have
A
to.
person registered under subsection 3 shall.
Mm.
Shall
And number
act as
2,
property.
Ghosh,
Yes, Lordship.
if you are covered by 6(4), mind you, the language goes as such that the person is a foreigner, but he is deemed to be an Indian citizen by operation of that 6(4)(6)(a)(2). He is not a citizen. He is a citizen only by operation of law.
But this says,
So will it also cover section 3?
yes, it is. My understanding, Lordship, I
Mhm.
may be wrong, Lordship, but what I understood by,
You don't read only one line. Extract extract one sentence and then say that this is. Read the whole of the structure.
yes,
Birth certificate, what is the date of birth?
prior to the date, Lordship, his date of birth as per the certificate. His date of birth 2/6/1980.
So he is born on to 6/1980.
Yes,
Then?
Lordship. Prior to 1st July 87.
Then
Six year, I know.
This will require a lot of hearing. It's too
Yes, sir.
complicated a law
Yes,
to be
Lordship.
just on. Better you find out something else. You have no other material.
He grew up as a destitute child.
Destitute. Then,
Because both the
no,
parents
just a
died.
minute.
Yes.
Then, whose son is he originally? Or the
He-
father is alone?
No, no, father, he knows, he's the name of his father. That
And who
he has
is the
said.
father a citizen?
Father is Sudhan Biswas.
Is he a citizen?
That no documents of, because his parents died when he was very small. So he grew up in the village, in the co-villagers' houses. So he don't have any documents. He is the only child of his parents.
What is your submission?
We have to go by the law logic. There's no separate law for a destitute or for a person who has no records. Lordship will take up this matter some other day. Let her also talk to him. Let us look at his condition. And then the meanwhile, give me a copy, huh? Our petition copy is missing. We just want to go into it. Okay, we will go on to this. Something must be there, Lordship, for that connection that his parents came to India, Lordship, or some connection, some link, some information. Or
What do you say that born before 87 is a citizen?
No, that doesn't apply because they are from the specified territory. You know, I do not have a copy of the petition. Let me go through it once properly, Lordship. And if the records are available, we can also go through the records.
Records are here.
And she has not spoken to him. We do not know what his condition is today, whether he is well, unwell. Lordship can take a call once the picture is clear. A medical board can be constituted for him to check up about his health condition.
No, no, why we are saying read 6A. It's very clear, special provision as to citizenship. And 3 is the general provision.
C doesn't apply to her at all, Lordship.
So the interpretation of law is whenever there is a special provision to a particular category of people, it is the special provision which is applicable, general provision is not applicable.
And 6A is only for the Assam and
See,
specific territory.
if you go by the legislative history of these things, possibly entire legislative history may not be very what expression to use, may not be maybe for a particular purpose in a particular manner. But what can you do if the legislators, they themselves missed out a point in trying to be overzealous or in doing something and left a loophole? What can you do? By the very provision, special provisions, it's a special law for this category of people. So the law of interpretation is whenever there is a special law in respect of a particular category of people, it is a special law alone that applies. And the general law is excluded from that category. 3, Section 3 was amended in a very skillful manner. But in doing so, they had totally forgotten about 6A and left a loophole there. So now to say that Section 3 is equally applicable across everybody, then you have to again now come out of 6A, only then that argument will be acceptable. But if you cannot come out of 6A, will the 6A category of people also be covered by 3? When 3 is the general law and 6A is the special law. Mhm.
If your argument is to be taken, then everybody is a citizen.
Prior to 87. What's
No, but that's not applicable to declare foreigners.
Not irrespective of that, irrespective of the parents.
No, it cannot be. Lordship, my friend says irrespective of parents, but 6A specifically states 6AD. A person shall be deemed to be of Indian origin. Yes, Lordship, if he or either of his parents.
Always means it's a special law. Special provision always means it's a special law.
Yes, Lordship.
And the principles of interpretation are very clear. Wherever the special law is applicable in respect of any category, the general law will be
Not-
inapplicable.
Yes, Lordship.
And it is a special alone which will govern them. Unless the legislature had made it more explicitly clear.
And the registration also, I'm not sure whether it is authorized by the government or some
Yes.
private people have
Yes, ma'am.
taken it up.
No. It's
No,
as
it-
per the registration of births and death act, this birth certificate.
No,
was
not the
prepared.
birth certificate. I'm referring to the refugee certificate.
This is refugee certificate.
No, that is the other matter. not
Other
this
case,
matter.
no, this case.
Confused, Lordship.
In this case, I have only one document.
That is the other matter, association. Okay, we'll hear you. When do you want?
Let it come up after vacation.
Lordship, in the meanwhile, the condition of the.
No, we
petitioner
are
may
concerned
also
with
be-
the medical condition of the
Yes,
person,
Lordship.
not on his entitlement or
Yes,
as a
Lordship.
citizen or not.
When the matter was fixed on 15th, prior to 15th, and after 15th, I could not talk to him, but prior to
Do
15th,
it.
because
So
via,
we list it
someone-
next week, list next week for further update on the medical condition of the petitioner. And as to in what manner the petitioner intends to avail the many medical benefits that
Yeah, he's in
are
Ipswich.
provided.
And his cancer was detected about 10 years back. I don't have the copy with me now.
not 10 years, in 2016.
2016.
Yes.
So
Almost.
So
Yeah.
present medical state.
Yes,
okay, that's-
that's-
It doesn't matter 15 or 10 or whenever
Yes,
it is.
yes, Lordship.
We come back next week. We'll take
Deeply
that
obliged.
time.
Item 18,
Origin. Same time. Adjourn on the prayer of Mr. A. Ali, Land Council Education, the Election Commission. For doing the needful as required by the order of 35/2023.
21st July. Item 19,
Mr. Mahmood. Page number. Petitioner is Saban Ali.
Of village, Kasu, Haiti,
Village,
Kasu. Similarly.
Kasok Haiti.
Yes.
Kasok Haiti, Saban Ali.
Similarly, voter list of.
And what is the name of the petitioner? Hasina Khatun. Hasina Khatun.
Page 70, is another voter list. 1970 voter list, page 16 of the same village.
Did you inherit any land of the Saban
Yes,
Ali?
yes. That lordship may kindly see page 29.
29.
29. Here, lordship may kindly see comment. Just from the certificate copy comment. as per the order of Circle Officer dated so and so.
No. On the left-hand column, where is the name of Hasina?
Hasina's name is there, madam.
Where?
Hasina's name is at page 32.
Huh?
32. 32, 32. Hasina Khatun. Sabanagi. And it is more clarified in page 29. Same village, madam.
Page 29 is the English translation.
Page 20 English translation, the SMS. That is page 30. Page 30, bottom may be seen right side.
Page 30,
Here, not-
bottom, Hafizuddin.
Last two lines.
Where is the name of Saban Ali?
Yes, page 30, bottom right side can be seen.
Sorry.
Page 30,
Huh?
right side, bottom.
No, in the left side, where is the name?
Yes. Shamanali-
Left side is the
Yes.
Patadaron Nam.
Yeah, right, left side, Shamanali is there, madam, but it is deleted.
Yeah,
It is deleted because of converting the Pata in the name of other.
Saban Ali. Saban Ali নাম তো কোথায় আছে? Saban Ali আছে। Sari number. And which voters list is the name of Saban Ali?
Shamanali, page 14 and 16.
Page number
14, 1-4.
1-4.
6. Village Kasubegi, same village. As 14 is the voter list of 1965 and 16 is the voter list of 1970. The same village.
Saban Ali Samad. Yes, what do you say?
Lordship, since 1985, Lordship, page 18, Lordship, onwards, Lordship, is of different village, Lordship.
Page?
Lonkajan village. Page 18, Lordship,
Who is Lonkajan?
Proceedings father, Lordship, Saban Ali, Lordship.
That was ship name. That we
Chief
have
dead.
agreed
And
in
till
our-
dead, Lordship, he is of village Lonkajan, Lordship.
No, that is okay. He may have gone, but Saban Ali is in Kasokhati, page 14, 65.
Jamapundi is matching, Lordship, but.
But
voter
in place of Saban Ali, the name of Hasina comes in, page 32. Page 30 is the name of Saban Ali, serial 4, and serial 19, Hasina. This is of Kasokhati. So where Saban Ali has gone, that is not our concern.
Lordship.
But when Saban Ali was there in 65 in Kasokhati,
That's okay.
Kasokhati, and his land in Kasokhati had also been inherited by Hasina. Unless, of course, this Hasina and the present Hasina are they are different people.
Yes,
That you'll have to make an inquiry.
yes, Lordship.
Otherwise, later on, where Saban had gone, that is not much material.
Yes, Lord.
We examine that whether they are same people or not. That Hasina who inherited land of Saban
Yes.
in village Kasokhati, whether petitioner and that Hasina, they are the same person.
Sabanali's names also included in the Jamapundi Lordship in the year 1975, Lordship.
It is there. We have noticed page 28 or 29, something
Yes,
like that.
Lordship.
Saban Ali is there.
Yes.
Heard Mr. M.U. Ahmed, Land Counsel for the petition. The petitioner Hasina Khatun had been referred to the Foreigners Tribunal number. Where is the order of the tribunal, Mr. Mahmood?
It's page 89.
89. Had been referred to the Foreigners Tribunal number 2 Nogao for rendering opinion as to whether he is a foreigner under the Foreigners Act 1946. Line to change course. Resulting in registration of FT case number 200/2015. Tribunal rendered an opinion dated 5/10/2018 declaring the petitioner to be a foreigner, being aggrieved the state petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of 1965 and 1970 also, and 1970 of village Kasokhaiti, police station Koliabor in the Nagaon district, which contains the name of Saban Ali, son of Tobu Sheikh. The father is Tobu Sheikh or Samad Sheikh? Who is the father of Saban Ali? Samad Sheikh. But come to page 17.
Nobu Sheikh.
The petitioner to produce the complete voters list of 1970 of village Kosokhaiti to examine the discrepancy in as much as Saban Ali in the 1965 voters list is shown to be Saban Ali, son of Samad Sheikh, aged 33, whereas in the 1970 voters list, Saban Ali is shown to be son of Tobu Sheikh. Whereas Saleman Nessa is shown to be wife of Samad Sheikh.
House number same in all three voter lists.
Doesn't matter. Your daughter-in-law becomes the wife of the father-in-law in 1970. And the son becomes the father of somebody else. So complete voters list of 1965 and
1970.
produce. Maybe some mistake is also there. Because Saleman Nessa is the wife of Saban in 1965. She cannot be the wife of Samad. Samad is the father-in-law. Sorry, next week. Sorry.
Next week.
You may also file an additional affidavit.
Yes.
Item 20.
This may be a mistake also. Just check up. It appears so. Jubbar
Yes.
Ali. Yeah.
Yes, Lordship. His grandfather's name appeared in 1966 and 1970.
Why this Jubbar Ali alias Abdul Jubbar?
Lordship, sometimes some persons called as Abdul Jubbar or some.
But he has to be one person. He cannot be two different persons.
Lordship. The village people, Lordship, they sometimes write their name in 2-3 ways, Lordship. Sometimes they are.
This we cannot accept it.
Lordship.
That will not make two different names to be the name of one person unless you prove it with material.
Notice was served as Lordship, Jubbar Ali.
Jubbar Ali, who is he actually? Abdul Jubbar or Jubbar Ali?
Abdul Jubbar, Lordship.
He's Abdul Jubbar.
Yes, Lordship. His name appeared as in voter list as Abdul Jubbar, Lordship. Page 21.
Did you point out to the tribunal that I am Abdul Jubbar, not Jubbar Ali? Did you take that stand? Why you didn't take that
Normally,
stand?
Lordship, the petitioners, when they receive notice, Lordship,
Sorry.
they write their own name first and then alias the in name which they receive notice, Lordship. Normally,
No, we are not on
Practice,
any
Lordship.
abnormal or normal situation. We are on the identity of people.
Lordship.
So if somebody, you are X, and somebody comes to serve you as a notice addressed to Y, why do you receive it? Suppose the man who forcefully serves it on you. First thing you go and take the stand before the tribunal that see, I'm X, I'm not Y. And you take your call, you are proceeding against Y or you are proceeding against X. Because otherwise X can never prove the identity of Y. How can you prove? Why don't you do that? You are agreeing with it, there must be something, you like the confusion.
Yes, because sometimes, Lordship, their name appears in some documents differently, Your
How
Lordship.
can it appear?
In this case also, Lordship.
No, no,
the
how
grand-
can it appear in a different?
Lordship, maybe at the time.
This is a
of
very
recording.
common, casually stands are taken, it appears differently, but how can it appear? Did your name ever appear in different name?
No, Lordship.
Then why the man, did the name of Madam Verma appear in any different manner? None of us. So why only these people who have a problem and issue of their identity? Why it always happens with them?
In fact, Lordship, at the time of recording name in the voter list, there are some discrepancy arises, Lordship. It
No,
is
that-
our duty to.
But
point
that
out
doesn't mean
Lordship.
the law is in your favor.
Lordship, and to file an objection in regard to that, Lordship.
These are explanations, not materials to prove any fact.
Lordship. In this case, Lordship, his grandfather's name is there in 1966,
Page number.
page 18, Lordship, annexure 1.
Who is the grandfather?
Miajan Haji, Lordship. Serial number 14. And grandmother is Kajoli Bibi. Korim Box is
Miajan Haji grandfather, Kazoli grandmother, and Korim Boxa is the father.
father. Lordship.
Okay, very well.
And Lordship will
Village
find,
is Kalipura.
Lordship,
So
Kalipura
now
part 2.
which
Your-
document will show
Your Lordship
that
will
Job-
find in the same serial number 14, the person's name was written as Miajan Haji. And later on, Lordship, at serial number 15 and 16, it was written as Miajan only, Lordship. So these are the.
Miajan and Miajan Haji, we are not questioning you.
These are the
But
discrepancy
Jabbar Ali
arises.
and Abdul Jabbar definitely will
Lordship.
question you.
Then Lordship, annexure 2, page 19. Grandfather
See,
Miajan
your
Haji.
name is R Chaudhary. R
Lordship.
must be having a particular name.
Lordship.
So either it is what? Roshan.
Roshanara.
Either it is Roshanara Chaudhary or somebody may ask you as Roshanara also without the Chaudhary.
Lordship.
But that doesn't mean you are a different person. But if it is entirely different, only the Chaudhary word is common. Roshanara is different. One is Roshanara Chaudhary, another is Chaudhary something.
Lordship.
Definitely somebody will ask a question whether it's the same person or not. So Miajan Haji and Miajan, there's no difficulty in understanding it.
Lordship. In 1970.
Anyway,
also,
which
1970, page 19, Lordship.
page 19, we have read it.
Miajan Haji.
We have read it. Korim Boxa, very well.
Yes.
Then after
Karim
that,
Baksha, Miajan, here it is written as Miajan Bibi, Lordship. And annexure 3, Lordship, that is page 20. Karim Box appeared as Karim Sheikh, Lordship.
how do you
Against-
know?
Against his father's name, Haji Miaja. Instead of Miajan Haji, Lordship, the Haji came forward to the name of Miajan.
Sukhitan is the wife of Karim.
Yes, Lordship. The mother's name is correct, Lordship.
No, that is okay.
And
This is
father-
also acceptable. Now after that,
Annexure 4, page 21, Lordship, 1989. My name appeared for the first time, Lordship. My father's name appeared as Abdul Karim against his father's name, Haji Miajan, Lordship.
along with Sukhitan.
Sukitan Nessa.
Okay.
My father's name appeared as Abdul Karim instead of Karim Box, Lordship. And Fazlur Rahman, my elder brother, Rahel.
So now who is noticed by the tribunal? Abdul Jabbar or
Abdul
Jabbar Ali?
Jabbar.
Abdul Jabbar is noticed.
Yes, Lordship.
Yes, sir. And you are Abdul Jabbar.
Yes, Lordship.
Then from where did the name Jabbar Ali came from?
Lordship, he
Then
was.
why
served-
did you write the name Jabbar Ali then?
His name appeared in the notice as Jabbar Ali, Lordship.
Notices Jabbar Ali.
Yes, Lord.
Notice which page?
Notice I have not enclosed, Lordship.
No, in the record which,
Impugn order itself, it
no,
shows.
in the record which page? Petitioner to find out. গণ্ডগোল হয়ে পড়ে নয় বেলেগ নামার লিখে নোটিস করে আর Jabbar Ali.
Yes, Lordship, to the.
It is Jabbar Ali
Lordship.
because when they go to make an inquiry, that verification,
Lordship.
these people, I don't know whether by instruction or by habit or by default, they always tell the name in a different manner. If the notice is being served to Abdul, inquiry is made against Abdul Jabbar, when the police will ask him, what is your name? He'll never say it is Abdul Jabbar. He will say it is Jabbar Ali. Thinking at that point of time, let me create this, begin this creation of a confusion so that I cannot be proceeded. And they are also astute enough that they'll go and serve the notice to Abdul Jabbar only. They'll not go and look around for Jabbar Ali and find out a non-existing person. Therefore, these discrepancies, this difference in name is always there. Tell me, suppose I am a person who do not know you. Today I go to make an inquiry. First thing I ask you, what is your name? If you are Abdul Jabbar, you say it is Abdul Jabbar. Why do you say it is Jabbar Ali? Because I have no business to write without I don't even know the person. Suppose if you say Abdul Jabbar, I have no business to write your name to be Jabbar Ali. Definitely it will be written as Abdul Jabbar. This is the beginning of this confusion, and ultimately you are at this stage. Neither you can prove your case, nor you can disprove your case. Why are you not, people are not more sincere and reveal the correct name at the first instance?
Advice was given to the persons.
In
Lordship.
general, some instruction advice is given. Somewhere, some leader somewhere must be saying, whenever the police comes to you, always tell a different name. And that is the only answer we find, because otherwise, same thing cannot happen in so many number of cases. Ultimately, you create the problem of alias, then you try to explain we are the same person. Then you say we are known by two names. Why will a person be known by two names? For nothing.
When I inquired from them, I
No,
came
no.
to know that if there.
And difficulty is we are having a little, that faith is coming down to some extent by going through all these matters for quite some time now. It's a creation of nothing else. Now what order will he pass?
Otherwise, Lordship, the voter list.
So
that
now we question them, then why do you serve it on Jabbar if it is for Ali? Their answer is, yes, Jabbar told his name to be Ali when making the inquiry. You yourself who is to be blamed. Can you be allowed to take advantage of your own misdeed?
At the time of.
See,
inquiry-
initially, we are believing these people and putting it across to them. But now it appears that it is the people who are misleading the authorities. So why should a misleading act be the basis for an order in your favor? So what else a tribunal can do other than to declare you to be a foreigner? Nothing else.
But not
It's your
in-
own creation.
Lordship, but in
See,
19
otherwise you had a very good case.
yes, Lordship, in 1980.
Had you been truthful
Lordship,
from the beginning, you had a very good case, but you tried to mislead. That's a beginning of your problem.
but Lordship, the tribunal held that 1985 voter list is from some different place, Lordship, Kalikora Part 1. But that is
No,
not
forget about part 1 and part 2.
Lordship.
These names keep on changing.
Lordship.
But what about your Jabbar Ali? Jabbar Ali is your own creation and nobody else's creation.
Lordship, the father's name is Abdul Karim, so he accepted the notice, Lordship, at time of inquiry.
No, at the time of verification, not at the time of accepting notice.
And
Why did the person tell his name to be Jabbar Ali? That is your
Abdul
first
Karim.
stage of your misleading approach.
Abdul Karim, Lordship, his father's name appeared as Abdul Karim, Lordship.
Maybe you are giving some other reply, madam.
Lordship, even the father has two aliases. Somewhere it is Karim Box Sheikh and somewhere it's Abdul Karim. Now, which one is the real father?
So Karim Sheikh, Karim Boxer Sheikh,
Yes.
Karim Box, we understand it is same person.
And Abdul Karim.
No, to that extent, we don't have a difficulty in it. Karim Sheikh, Karim Boxer Sheikh and Karim Boxer,
Abdul Karim.
they may be same, not Abdul Karim.
Yes.
How can Boxer Sheikh become Abdul all of a sudden?
Karim Sheikh, Lordship. Karim
Lordship,
Sheikh,
Ju-
but
Lordship,
against his father's name, the Haji Miajan is there, Lordship.
Madam Chaudhary, we have no difficulty in accepting Haji Mia Haji, Karim Sheikh,
petitioner, no?
Karim Boxer Sheikh and Karim Boxer. Karim Boxer, Boxer Sheikh and Sheikh are one and the same person. We accept it. Dear citizens also, that also we accept it. How do you accept that Abdul Karim is the same person?
Lordship, page 23. Jabbar Ali, now my friend is relying that his name is Abdul Jabbar. Here the name changes Jabbar Ali Sheikh. That means
Now
this is a-
Jabbar Ali, son of Karim Boxer.
Yes. Page
So Jabbar Ali may be an Indian citizen being son of Karim Boxer. But Abdul Jabbar may not be. Abdul Jabbar is a son of Abdul Karim. These two Abduls may be different people.
Maybe,
His
Lordship.
mother's name is same, Lordship. Shukitan Nessa is there,
It's a
Lordship.
common name, Lordship.
Shukitan
But
Nessa
it
is
is
there.
you who is taking all the different stands.
No, Lordship, grandfather's name and Lordship, the mother's.
Madam
name
Chaudhary,
remains same.
there's nothing called grandfather, father, brother in these proceedings. Yes, everything has to be established. Just call him X to be my grandfather, it does not make him mean to be grandfather. So Jabbar Ali, Karim Boxer Sheikh and
Haji Mia.
Haji Miajan. These three names, being three generations, we have no difficulty in accepting it.
Lordship.
Difficulty is in between somebody becomes Abdul Karim and he becomes Abdul Jabbar.
Lordship.
This Abdul Jabbar and Abdul Karim, we are not interested. So now this petitioner is Jabbar Ali or he is Abdul Jabbar.
Lordship, sometimes his name appears as Abdul Jabbar.
That
and
we don't
sometimes
accept.
Jabbar Ali, Lordship.
We never accept those statements.
Lordship.
It has to be one person. Either you are Abdul Jabbar or you are Jabbar Ali. Who you are? Who is the petitioner? Because very conveniently, difference depending on the voters list that is relied upon, the name very conveniently changes.
No, but Lordship, in 1989, mother name and grandmother name remain same, Lordship. Page
No,
21.
1989
89.
is acceptable.
Yes, Lordship, 89.
No,
Lordship,
18 name is, this is acceptable, but this is Abdul Karim.
Abdul Karim. my
Abdul
father-
Karim, he is the father of Abdul Jabbar, we accept.
Abdul Karim is the son of Haji Miajan.
So how do you prove all this? How do you prove it?
Grandfather name remains
Understand.
same, Lordship.
You are only explaining. How do you prove it?
Lordship, these are the discrepancy occurs while preparation of the.
So how do
voter
you
list,
prove it
Lordship.
that they are the same person?
An inquiry can be made by the election authority.
No, no,
whether-
first you prove, then they'll
And Kalikura part two, Lordship, when this.
understand.
1989
You first prove it from your side, discharge your burden, then I will ask them to make their
Then I
inquiry.
can file an application before the election authority to. Lordship
Find out
submit-
how can you prove.
Lordship.
No? This Abduls may not be.
Lordship, even the election commission cannot say that Abdul Karim voters in. And Lordship, the father's name has kept on changing from 66 Karim box. Again, if the first voters list where she's referring is. the
No, we understand that. Karim Sheikh, Karim Boxa and Karim Boxa Sheikh, this may be possible. One name gets dropped out somewhere.
Yes, Lordship.
But dropped out doesn't mean the name changes to something different.
Abdul is a
Karim,
completely.
Karim is there, Lordship. But it changing from Karim Sheikh, Karim Baksha, Abdul Karim, Lordship. Otherwise, Lordship.
Madam
2000
Chaudhary, what you indicated is a
Right.
particular word being dropped from the name is a different context. The name get changed to something different is a different context. Suppose you said your name is Roshana Chaudhary. In a given document, you are written only as Roshana Rai. Chaudhary is not there. We have no difficulty in accepting that it's the same person.
Lordship.
But in another document, you become Chaudhary something else. Then the question comes whether Roshana Chaudhary, Roshanara and Chaudhary something else, that Chaudhary something else is same person or not. Only common will be the word Chaudhary.
Lordship.
This is what we are asking you. And this answer we are not getting.
Lordship, then I will file an application before the election authority to provide me the.
Bring
information
the
whether
complete
these are the-
voters, bring the complete voters list of
That,
all these
Lordship, I have already filed, Lordship, that I have already filed
page
by
number
additional affidavit, Lordship,
number?
page 42 onwards, Lordship.
42 onwards.
Lordship.
What does it say?
There was already an order, according to that, I have filed, Lordship,
Hmm.
annexure
Can you
15,
refer to those documents where? referred to?
annexure 15, page 45, Lordship.
45.
And the
Kajoli Bibi and Karim box.
Lordship.
This is
Miajan Haji, my.
This is even shorter than the page 19. Page 19 at least contained 3 names. Now you are containing 2 names. And you were saying it's a complete voters list.
No, Lordship, Miajan Haji, Kajoli Bibi and Karim box.
It's same as page 19. How can you call it to be complete?
My grandfather, my grandmother and my father, Lordship.
Kajoli Bibi, Karim box. Niagan Haji. No, these 3 names are only there for inbox. So what happens in the later years?
This is 1970.
I understand 1970. Where is the complete one of? This is page 49 is of
49 is of Lordship.
which year?
Of the
No,
Kalikura,
no, 49.
250 Lordship, that is 250 serial Karim Sheikh.
No, 49 is of which year? Nothing is written there.
That is, I have collected from the village people, Lordship. It is not certified copy, but the
No,
names
no,
were
suppose
written.
we accept it that way also, but it
Karim
is,
Sheikh,
but
Pita
it's of which year?
1985.
55. Do one thing. You produce the complete voters list. Like the page 46 type, why don't you produce for the other years also?
1989, I have submitted page 51.
51.
$225 serial number. Lordship.
225. What happened to Miajan Haji? Died?
Yes, Lordship.
Where is the name of Sukitan Nessa in 1970?
1970, Lordship, page 45.
Why that name is not there? Karim Sheikh is 44 years. Miajan Haji is 80 years. Kajoli Bibi is 65 years. Then neither Kajoli nor Miajan is there. All of a sudden he becomes Abdul Karim, and Sukitan Nessa, 60 years, is his wife.
Lordship, 1970.
So 60 years in 1989. So that means must have been 41 years in 1970, Sukitan. Sukitan names ought to have been there in the voters list with Karim. Page 51 and page 46.
Yes, Lordship. Page 46, Sukitan's name is not there.
Is the name of Sukitan anywhere there?
No, Lordship.
That name ought to have been there. Then we could have easily accepted that Karim Sheikh and Abdul Karim may be the same person.
And there is a discrepancy in age also, Lordship, 1970.
No, we have noticed it. If you go by 1970, it ought to have been 63 years, but it is 73 years. We are ignoring it.
Lordship.
For your benefit, we are ignoring that one.
Lordship.
But
Her name,
if
Lordship.
Sukitan Nessa, 60 years, is the wife of Abdul, 73 years,
Lordship.
then Sukitan also ought to have been in 1970. Yes, she was 41 years by that time.
Yes, Lordship. That
Why is it not there?
her name is not.
Then we would have accepted that Karim Sheikh and Abdul Karim may be the same person.
Lordship, that instruction I will take.
Petitioner relies upon the voters list of 1970 of village
Kalikura Part 2.
Kalikura Part 2, which contains the name of Karim Sheikh, son of Miajan Haji, at serial 16, showing his age to be
44.
no Karim Sheikh, no Karim Box,
Box.
showing his age to be 44 years.
Lordship.
Reliance is also placed on the voter list of 1989 of Kalikura, Part 1 or Part 2? of Kaligura Part 1, which contains a name of Abdul Karim, son of Haji Miajan, at serial 225, by showing his age to be 73 years, and that of Sukitan Nessa, wife of Abdul Karim, at serial 226, showing her age to be 60 years. If Karim box of the 70 voters list and Abdul Karim of the 1989 voters list are one and the same person, the petitioner to explain why the name of Sukitan Nessa, the wife, did not appear in the voters list of 1970 along with
Karim box.
Karim box. Find out if it is there, maybe we have made out something.
Worship, then a short date may be given.
This
and
also.
Only interim,
Sorry.
there was a direction not to deport him, but worship, there was.
You want that to be recalled? The direction not to deport is recalled on the prayer of MS
He
Archer.
may not be arrested, Lordship,
Not recalled, it's already there. Interim order is already there.
not to be deported, but in that case, Lordship, he can be arrested.
3 days, Lordship, nothing has happened.
But 2019, how can you change
Yes,
the interim
Lordship,
order after 4
so
years?
I have filed
Yes,
this
sir.
additional affidavit in the year 2023, when they.
No,
informed me
no,
that-
for modification of an interim order, you have to file an IA. And that too after 4 years,
Lordship,
unless you show some circumstance that there is a likelihood of arrest,
Lordship.
then they will protect you, definitely.
Then after vacation, Lordship.
After
immediately-
vacation. yes. Any
immediately
date
after
you want, please choose the date.
June, July, Lordship, 18 July, Lordship. Apply.
Even hold it to.
Item
20, Lordship.
21, it is next 21. Item 21,
21. Who is the father? Subidri Sardar. Who is the father?
Father is Chanakya Ranjan Sarkar.
Sorry, page number,
Chanakya Ranjan Sarkar.
page number
Page number Lordship 66.
66.
Original is there in the record. Page-
Chanakya Sarkar. What is this application for a migration certificate?
And her name also is there.
Just a minute. Chanakya Rangam,
Ranjan.
no Rangam, G. And
Sarkar.
Samitri,
Sabitri, same,
which one is Sabitri?
Sabitri 4.
Oh, Sabitri Sarkar is some 1 year.
Yes, when parents had migrated.
Mahendra Sarkar, Mahadev Sarkar. Who are they? So this document has the seal and signature of some authority.
Yes, its original is there, page 98 to 100. In the
This one is dated
dated Lordship.
Mhm. I think you'll have to consult the records. This
Yes,
is,
record is page 98 Lordship.
no, this photocopy is not very legible.
Yes, mine also is not very old document, so yes.
Maybe
Lordship.
the original one
Yes,
will be better revealing.
page 98.
Mhm. Equality oil, and this person is the same Savitri. And this is a 371 document. Good enough, I'll get it one another.
Page another.
আর আমি ফোন করবো বলেছে, করিল। Savitri. 89 voter is Savitri, this is husband of Rotindra, not daughter, I think.
Husband with husband, lordship. Voter list in a page 70. Yes,
To the migration certificate issued.
Robin.
It's a- Yeah, so. Number voter given. Date to goal. Unfortunately, the date
Yes,
itself,
lordship.
something fell on that, the date goes. Date does not remain. Have you noticed it?
Yes, my colleague, the date she told. me.
Migration certificate issued, number is there, but the date is gone. 26 month and year is not there. It's been 0 to 9. What is the heavy date? Exhibitor date. Hey, dear friend, oh. Somewhere in the middle, just look that migration certificate issued, and then one number is there, but around the date,
Yes.
something fell on it. 24 is visible.
Yes.
The month and the year is not visible. It's not there.
My God. Deputy Commissioner.
Mr. Sharma, anyway, that one looks to be a very, very old document,
yes,
and it does not appear to be any manufactured document or
Yes,
anything like that. Maybe some leaking roof, some water fell on it or something of that kind must have happened in that thing.
Let government may take the instruction.
Sorry?
Let government may take the instruction regarding that document, lordship.
Do you have maintained so much of records?
I think. Deputy Commissioner issue করেছিল।
But if this document is accepted, they have proved their case.
Yes,
Because the name of the petitioner also appears in that document.
yes.
If it is available, my lord, if I can get the, I can give it try.
If it is available, you are most welcome.
My lord.
But are the records maintained so meticulously? I doubt.
Old document, my lord, it seems to be my lord.
What exhibit is that?
Exhibit A, lordship.
The exhibit A available at page number?
Page number exhibit
98,
98,
lord.
98.
No, take one, please. No, take one, record doc. Available at page number 98 of the records. কি হলো? Record is a application for grant of refugee migration certificate where there is an endorsement bearing a registration number that the migration certificate had been issued. The application is by what Sarkar? What Ranjan Sarkar?
Chanakya Ranjan.
Chanakya Ranjan, Ranjan to Razan लिखिबा Ranjan Sarkar, wherein the name of his children are also provided, which contains the name of Savitri Sarkar. It is claimed that Savitri Sarkar is the writ petitioner herself. The date, the document, although looks prima facie to be a very old document, but unfortunately the date along with the certificate registration, certificate number had been rendered illegible. MSU task and counsel for the deputy commissioner, which district?
This is Nagaon Lordship.
Nagaon praised for an adjournment to explore as to whether the records contain any further material on the said exhibit A.
Madam,
You can have a photocopy of that one. Make a photocopy from this one, because the one in the petition is not legible at all. Next slide.
Item 24.
Deeply.
Sabita Saha, yes.
Savitri Saha.
well, let's continue, kindly see page 22, annexure A, NRC 1951.
The original order is you have, right? Mhm. I know the original order.
Savitri Saha. Huh?
That's order they highlighted.
24, but it's not.
Yes, Mr. Chauhan,
Yes. ma'am. So, kindly see page 22,
page number.
22, annexure
22.
A. Number 1, my lord, Jatindra Kumar Saha,
Jyotinra, who is Jyotinra Kumar?
father of the petitioner. my lord.
Sorry,
Father of the petitioner. my lord.
but this is NRC. It
Yes,
is not admissible in evidence.
yes, my lord. Thereafter, my lord,
Any other document?
yes, my lord. The husband of the, father of the
Mhm.
petitioner, my lord, purchased a plot of land in the name of
That page 24.
page, my lord, 24 years to me.
Who is the father?
Father, my lord, Jyotindra Kumar Saha.
Jyotinra Kumar is the father.
Yes,
And who is the petitioner?
petitioner,
Sabita Saha.
Savitri, my lord.
Huh?
Savitri Saha. my lord.
In the cover, it is written Sabita.
And the name of the
Anyway,
father is, my lord, Makhan Bala Saha. my lord.
so Jyotinra is the father.
Father, yes, ma'am. Makhan Bala is mother.
Makhan,
Bala Saha,
she is the mother.
mother, yes. Mother of the petitioner.
Okay, Makhan Bala, mother, wife of Jyotinra, purchased a plot of land in 1963
Three.
at village. Where was the land?
Hojai,
purchased?
my lord. Hojai, my
Uh,
lord.
Was the
Hojai,
land also in Hojai?
yes, ma'am.
Hojai town, very well. So now which evidence will show that Sabita is the daughter of Jyotinra?
My lord, that is from the evidence, my lord. Page,
Evidence of
evidence DW2, 63, kindly see page.
who is DW2?
The brother, my lord, brother of the petitioner.
Brother. How do you know he is the brother?
My lord, evidence shows, my lord. Evidence of the DW2, my lord. Sushil Saha is the brother.
How do you know that he is the brother? His evidence is there.
Yes,
But how do you know that Sushil Saha is the brother?
he himself, my lord, stated.
Himself state.
Yes,
He is himself stating evidence. What is the difference between a person making a statement and evidence? Is it one and the same?
my lord,
See, suppose today I make a statement. Yesterday I was sitting in the court, although it was Sunday. Will it become evidence? Or will it make it that the court was sitting yesterday?
the school document is there, my lord.
Ah.
Marriage certificate is there.
Forget about that. If you rely on DW2, first you show DW2 is the brother. One way of
Yes,
doing
my
it
lord,
is
there.
Makhanbala is the mother. Show any document which will contain the name of DW2 and Makhanbala together in Hojai town. Any voters list, any
lord,
such document?
Page 38, my lord.
38.
38, my lord. Annexure E.
38 annexure. This is again NRC.
Sushil, my lord.
Sushil is the brother.
This is again NRC, 38 has no value in evidence. The petitioner may produce any relevant material in evidence which may show that DW2 is the brother of the petitioner, or in other words, is the son of Makhanbala Saha, wife of Jyotindra Saha of Huzai town. Liston. In
26.
some voters list of Makhanbala and that brother together. That will be
In the land document is there.
next item.
Item 26.
Anything, whatever you have. Yes, item 26.
Lordship,
Who is the petitioner? Sahera Khatun. Yes. Who is the father of Sahera Khatun?
father is Abdul Quddus.
Page number?
Page Lordship, 66, page 59, 66 voters list.
59. Abdus Quddus.
Yeah,
He is the father.
Abdul Quddus.
He is voters list of 1965
Yes.
and
Kuchia
village.
Bandha.
Village.
Kuchia,
Where do you get the name Kusia Bandha?
in
Kusia
the-
Bandha,
in the
yes,
page.
something is there. Very well. Which document will show Abdul Quddus is the father?
And then same in 70 also, Lordship.
It's okay.
Yes. the
Which document will show
document,
he is the father?
Page 71, Lordship.
71.
Yes.
Land holding certificate, Dalla Revenue Circle. Baki Billah Mia. Who is Baki Billah?
Is the brother. Brother, and he also has adduced evidence.
Is it admissible in evidence? Land holding certificate, Mr. Sharma?
Even Jamabandi is also right.
Jamabandi is also there. Where is the Jamabandi?
Jamabandi, page 73, Lordship.
73.
And if we see page 74. Tithar Chokro.
Tichar Chokro Bihoyar,
Yes,
actress Sari, I think.
yes, Chris At
Actress
Uthoro Ingrazi Tarikor.
Ingrazi Tarikor Hukum Mate. Waris, say something, where are the name?
Or Waris Putre Ek number. Sahera Begum,
Petitioner is Sahera.
yes, Lordship. And then Lordship, serial 6 is that Baki
Pita-
Billah,
Pita Kuddus Miar Namzari Kora.
yes.
This is regarding land of which village?
Same village, Lordship. It's written in page 72, Lordship. Kusia Bandha, Gawar. It's page 70 on the top, Lordship.
Kusia Bandha.
Yes.
Sikhanda.
Kusia Bandha.
Kusia Khanda,
Kusia Bandha.
Bandha,
Khanda Niki. Kusia Khanda.
Khanda. Same village.
What is the meaning? Any idea?
Kusia.
Kusia Khanda, any idea?
Kusia, I know it's a kind of fish. Khanda.
Kusia, whether you call it fish or something else,
Yes, Lordship.
they remain inside the mud,
Yes.
especially on the shallow watery
Yes,
places.
Lordship.
So you have to dig it out and then take out.
Okay.
So in that place, this Kusia Khanda. So they dig it. Okay, anyway, Kusia Khanda Gaon.
Yes.
Yes, Mr. Sharma?
Lordship may remanded back,
Hmm.
have no this thing regarding that Lordship, but the Sahara Khatun of village.
But only thing is that now it is Kuddus Mia, other one is Abdul Kuddus.
Kuddus Mia. It's R is there.
I is also there.
Yes, Lordship.
Present petitioner is of village,
Ah,
Pilasapara Bazar.
Heard MSD Ghosh, then counsel for the petition. Also heard Sharma also. The petitioner Sahera Khatun had been referred to the Foreigners Tribunal number
Number 2, Barpeta Lordship,
number 2, Borpeta,
page 31.
for rendering an opinion as to whether she is a foreigner under the Foreigners Act 1946, resulting in registration of FT bracket second case number 217/18. Tribunal rendered an opinion dated 11/8/2022 declaring the petitioner to be a foreigner. Being aggrieved, the strict petition is instituted. In the writ proceeding, the petitioner relies upon a voters list of 1965 of village Kusiakhanda. What is the police station? Horvok.
Yes.
In
Lordship.
under Horvok police station in the present Borpeta district, which contains a name of Abdul Quddus, son of
Kalimuddin.
Kalimuddin at serial 100. And it is claimed that Abdul Quddus is the father of the petitioner. To substantiate that Abdul Quddus is the father, reliance is placed on this is Chita or Jamabandi?
This is Jamabandi, Lordship.
A copy of a Jamabandi in respect of a plot of land at village Kusiakhanda, wherein, as per the order of the circle officer dated 31/8/2018, land was mutated in favor of Sahera Begum in place of A. Quddus Mia. Accordingly, it is claimed that as land in the name of A. Quddus Mia had been mutated in favor of the petitioner of village Kusiabanda, and Abdul Quddus, and the name of Abdul Quddus appears in the voters list of 1965 of the same village, the petitioner had discharged the burden under section 9 of the Foreigners Act 1946. In view of the above, remanded back to the tribunal to examine the voters list of 1965 of village Kusiabanda, as well as the other subsequent list of the same village, which the petitioner to produce incomplete before the tribunal. You produce it. If it is there, you point out to the tribunal, before the tribunal, as well as the Jamabandi of the plot of land of village at village Kusiabanda, including the order of the circle officer dated 31/8/2018, and thereupon pass a reasoned order. Respondents in the Home Department to make their verification as to whether Sahera Khatun, the writ petitioner, and Sahera Khatun, whose name appears in the Jamabandi referred above, are one and the same person. Upon doing the needful, a reasoned order be passed. Something?
Lordship, in Jamabandi Saira Begum.
Agoto Sahera Begum Kolo, no? Are we to
Saira Khatun.
Khatun? Respondents may also verify whether Sahera Begum and of the petitioner and Sahera Khatun of the voters list are the same person.
Deeply obliged, Lordship.
28,
Please, your lordship. Lordship, I am making a mention, extremely sorry, my lord. I
Adjourn on the prayer option. So,
obliged.
29,
29, who is appearing? Yes.
Maybe Lordship, my senior is coming from another court to find matter.
He was Kishore, I was typing. Let them come.
34 orders.
30 PL.
29 to time being.
Yes, Mr. Bothapur, who was here for some time back.
Your Honor, Mr. Botavaj and Lex Codon 7.
In any event,
We'll take up later. Next item. 31 IA.
31,
IA is for what purpose?
Please, your lordship. 31, we have the file that I have to extend the date of releasing the amount, my lord. Then
Yes,
Okay.
2 months,
2 months.
2 months may be given, granted.
And.
Sorry, can't hear you. Is the microphone on? Just take
My lord, 2 months maybe,
2 months time may be granted.
and the fix that may be fixed, my lord. A fix that the SC has agreed.
Okay, anything you agree. Heard MSA, Gahan and Council of Petition, also heard Mr. H.K. Mahanta and counsel for the opposite party, D.K. Datta and others, and another. This interlocutory application is instituted by the Union of India seeking for an extension of the time for doing the needful as per the order dated
9 March.
9/3/2023 in CR bracket HC 16/1994. So that matter, that
Yes,
30-year-old.
Yes.
By the order of 9/3/2023, there was a requirement of the respondents therein, that is the applicant in the present interlocutory application, to what? What was the direction?
Direction was, my lord, that is page number 16.
To pay an amount of rupees
20 lakhs.
20 lakhs each in respect of the 5 deceased persons to be deposited before the registry of the court within a period of 2 months from the date of the order. By this interlocutory application, an extension of the date for payment of the said amount is being paid for. Mr. Mahanta, led counsel for the opposite party, who is the writ petition, that is the writ petitioner in CRH 1694, do not object to the prayer for extension. Accordingly, as paid for, the amount may be deposited in the registry within a period of
2 months.
2 months. my lord.
That is on 19th August.
uh,
On or before 19th August.
within a period of 2 months, which according to Mr. H.K. Mohanto is required to be specified to be on or before 19/8/2023. Accordingly, the amount may be deposited before 19/8/2023.
Must-
Item 32.
Yes, what is this, Ivy?
I'm praying for minor correction.
Sorry,
I'm praying for minor correction, Lordship.
what correction?
Lordship, page 8, Lordship.
Page 8.
Lordship. The name of the petitioner is Anwar Begum, Lordship. Here, Lordship, daughter of Suban Ali, Lordship. Here it would be Saban Ali, Lordship. S-A-B-A-N, Lordship.
Sorry.
S-A-B-A-N, Lordship. Saban,
So you want to make Suban Saban?
Lordship, Lordship.
You have to change the cause title in the writ petition. Otherwise, how can we correct in a certified copy?
Lordship, in the writ petition, it is reflected as Saban, Lordship.
Saban.
Lordship.
Then make an application to the registry to give you a corrected certified copy. We cannot correct this cause title is not a part of the judicial order, so we cannot correct it.
Lordship, Lordship. Lordship, I will make application before.
I think the registry had given you an, but these are all in nowadays in the computer system.
Lordship,
No one types out the names.
Lordship.
Whatever name you had given in the writ petition, that will, yes, it is Saban Aldi, right? Type to নকৰে নহয় এইবোৰ কিন্তু CS system থাকে simply the name is taken out. It is very good option. Let's go down. Where's the photo? Yet to Subon Curiosity. Certificate copy. The registry to verify and submit a report as to why when the name of the petitioners in the cause title of WPC 1066/2018 was depicted as Anwara Begum, aged 41 years, daughter of Saban Ali, SABAN. That's a ... video. The certified copy provided to the petitioner depicted the name Anwara Begum, daughter of Suban Ali, ... Report be submitted on the returnable date, list of next week.
28. 28.
Check it.
Lordship. Yeah, Lordship, another error, Lordship.
Soburjan and Sokurjan.
Lordship, that is my mistake, Lordship.
I think page 32 you had translated wrongly.
Yes, Lord.
Mhm.
Yes, Lord.
Therefore, the wrong name came in.
Yes, I admit.
Vernacular, it is Soburjan, no
Soburjan,
doubt,
yes,
but
yes.
when you made the
Yes,
English
yes.
translation, you wrote it Sokurjan.
Yes. Instead of B, K.
We'll correct it next day.
Lordship.
The Sokurjan will correct it.
Lordship. Okay.
33 to 50 for hearing.
But I made a prayer in the morning for item number 42. Where I had prayed for, there was an order of the Honorable Chief Justice.
What is the order?
The order was that the OM, the judgment which was passed in the Bhagwan Patar, that was overruled by a cabinet decision in the form of an OM. And we approached the court.
No, we had started the hearing with WA. Mr. K.N. Chaudhary had started his argument.
Yes.
This is what I remember.
Yes, Manoj, there are 3 writ appeals.
So
we have
let
no
us
grievance.
continue with the hearing of the writ appeal.
Manoj, only my prayer was that since they have given effect to the OM and the reserves are being brought down the entire.
No, let us do the hearing only, then you'll get the relief.
My lord, may I submit, my lord? I have filed an IA.
In which one?
That is in item number 39.
No, these matters, we have just see.
I understand, my lord.
Let us finish it off wherever it goes.
No, but the
It's-
fact remains, my
Because
lord.
it's now continuing for, I don't know how many years it is going on and on.
Late 16.
And here is interim order, there is some interim order, it's all a mix up.
In fact, since your lordship has taken it final hearing, at this stage, a vacating application is.
Let's clear off the whole
Let
thing
me
in
submit,
one go.
my lord.
Huh?
If
Yes,
your
please.
lordship gives me 2 minutes time, I'll satisfy that, my lord, that the interim order which has been passed, it stops our promotion at the same time, it will stop his promotion also, my lord. And one person has.
No, Mr. Chaudhary, why don't we complete the hearing?
My lord, my clients are retiring in July, one of them is retiring in
Let's
July.
complete it before July.
No, I have no objection to that, but if you're.
No, only when the matters are started and the things are proceeded, then only we can complete.
My lord, I understand, my lord.
Let us do that.
My anxiety is that, my lord, this order,
No, this is the difficulty I remember. I have seen some of the orders.
my lord.
The hearings are not taking place. Somebody is getting to retire. Somebody is having all interims order in different directions are passed at different stages. So let us take a complete call. You'll get the order before you retire.
My lord,
If you
that
allow
is
the
a-
hearing to
my
take
lord,
place.
If your lordship kindly takes up my lord, for my IA, my lord, for 2 minutes, my lord, your lordship will be happy to, my lord, modify that order. And that will benefit him also, my lord. One person has stopped my lord, there are 12 vacancies in the additional chief engineer, all the posts are vacant now. There is not a single, my lord.
So let us
additional
hear
chief
it, that's
engineer.
why.
Absolutely.
So that you get the benefit.
But if your lordship kindly sees the order, my lord, one person has
Understand,
blocked.
Mr. Chaudhary, we appreciate what you are saying. But let us, in spite of continuing all interim after interim and interim in one direction, interim in the other direction, ultimately some are getting, some are not getting. Let us take a final call.
My lord, the only worry is, my lord, before the matter finally, my lord.
You
comes
see,
for-
Mr. Chaudhary, if you allow us to do our work only, then you can have a judgment from us.
So far as. my lord, the
And
hearing
that depends how all the parties are cooperating before the court.
My lord, so far as the hearing is concerned, my lord, I am not trying for, my lord, I am ready for the hearing. I
So
am ready for the hearing.
ultimately, the judgment to be given in the hearing will cover your IA
My lord,
also.
by that time, my lord, they may retire. That is the only worry.
So you are raising an issue that a court will not give a judgment.
No, my lord, that I cannot, my lord, that is an apprehension of the, my lord. Of the
That
petition.
apprehension can be answered by the conduct of the parties. If you are ready to cooperate a hearing
I am, my lord, I am
and you
ready for
complete
the-
the judgment today, you'll get the judgment tomorrow also.
My lord, I am ready for the hearing.
So let us do it. That is what I am saying. Because I have seen some of the order sheets, all different kind of interim orders, different stages. Everything is
My
ad
lord,
hoc. Let us take
Getting
a-
my lord, taking an interim order to, my lord, one's own detriment is something, my lord, is not understandable.
Who had taken? You had taken.
No, my lord, my
No,
learned friend has
but
taken.
I beg to differ with my learned counsel.
This, we are not going into
Yes,
this debate now.
My lord, I will never take a order in my detriment.
Let us start with the hearing.
Yes. I
We are
will-
hearing item 33. That
Yes,
was
Lordship.
read it.
I will go.
Mr. Chaudhary was,
Yes, he was arguing for the appellate.
where is Mr. Kane Chaudhary?
Lordship, he's in legs in other court.
Well, what we do now?
But Lordship, in the basic points here is.
See, just now we refused Mr. Chaudhary saying we are going into a hearing and immediately the next moment you saying that somebody is inconvenienced.
Lordship, I
That-
apologize, Lordship, but
And ultimate result is everything is pending.
the core issue is that Lordship, the constitutional seniority, Lordship, and I think Lordship and that and that.
We
and
don't
that
want
context,
any part-time agreement, part-time argument, I mean.
Uh,
Start.
Lordship, Lordship, the core issue is that Lordship, the constitutional seniority, Lordship, in that context, Lordship, my senior has already submitted, Lordship.
Then other solution before us is adjourn it for the next few months. Let all interim orders remain as it is. If anybody is inconvenienced, if he has the consequence, anybody is getting the benefit, he'll enjoy the benefit.
Actually, Lordship, he has already submitted his.
So his submission is over.
Not over, Lordship, he reserves the right to reply, Your Lordship.
Reply you always have. No one can stop.
Yes, Lordship, in that case, Lordship, my
So
senior.
let's,
my senior may start, Lordship. The senior colleague may start.
so let us hear.
Yes, I'm here, Lordship.
And we have recorded the submission of Mr. Chaudhary. Referring to OMR 14, more particular clause 14, raised the contention that as all existing orders on the subject are deemed to have been amended by 14. Therefore, even the provision of OM dated to 2002 providing for consequential seniority has also stood amended. This was the submission he made. So we had taken note of the submission. Let us hear the other side now.
What a paragraph.
So now we are required to interpret clause 14 of OM dated 2014. Whether it had amended 2002 or it had not amended 2002. Very well.
Well, to the submission of my learned friend that the clause 2014 amended the. What is it? Clause 14. 2014 the clause. Maladi, since on the last occasion I was not present, Maladi, submission was advanced by.
So, Mr. Das, for your information, we have recorded in our order so that this confusion doesn't remain what was submitted, what was not submitted. Submission is clause 14 of the OM dated 2014 amends the earlier provision of 2002 whereby consequential seniority was,
That is their submission.
that is Mr. K. N. Chaudhary's submission,
Yes.
not Mr. M. K. Chaudhary.
Yes, and to that I have a counter.
Now you please reply to that.
Maladi, Lordship,
I'll just clarify, my lord, before my. My lord, that issue is regarding the consequential seniority.
No, this
Yes.
is what he submitted,
Yes, my
Mr.
lord,
Chaudhary.
and my big case is a little different, my lord. I have to.
We'll hear it one by one, don't worry.
So the
And
submission,
if all of you are ready, tomorrow we'll give it a whole day.
My lord.
Argue, finish it off.
Maladi, your Lordship will take up page 79 of the writ appeal.
Page 79 of the read.
That is the OM of 2014.
2014.
Yes.
No. 2014 is at page
Is that-
45.
Maladi, page 79. IV Gohai's writ appeal.
Huh.
Item 33.
Yes.
Page
This-
39.
This is my flagging, Mr. Das. This is my
Well,
flag.
this is the appeal given to us by.
And this flag mark is at page 45. Maybe the same document is annexed by, just take a. Sometimes what happens while annexing the writ petition along with annexure, same document is available at two different pages.
Your Lordship will come up to the page 45, the 29 December 2014 OM. My learned friend, Mr. K. Chaudhary had argued that clause 14 basically amends the 2002 OM by which the benefit of 85th amendment regarding accelerated promotion and consequential seniority was given to the members of the reserve class. That is the.
2002.
Yes.
Ah.
So my contention is that the 2000 clause 14 of the 2029 December 2014 OM in does not amend the 2002 OM. Rather, what happens, Lordship? The 2014 OM is a set of guidelines to implement the Supreme Court's R.K. Sabharwal's case, that is post-based reservation. If I may read the first part of Annexure B, page 45. Implementation of post-based reservation. Can I read, Lordship?
Yes, yes.
Consequent upon the amendments made in the Assam Scheduled Caste and Scheduled Tribe reservation of vacancies and post 78 and acceptance of the recommendation of the one-man commission constituted by the government of Assam by notification dated 24th October 2003 with Harish Sonwal as the commission to study and acquire quantifiable data on backwardness of scheduled caste and scheduled tribe, their inadequacy of representation in government service and post and impact in overall efficiency in public administration. The following guidelines has been prescribed in order to implement the post-based reservation in matters of reservation of post for SC and ST, plains and hills in direct recruitment and promotion. The Lordship will come to page 49, clause 14. Yes. So my submission is that in clause 14 at page 49, your Lordship will find clause 14 of that same OM, page 49. All existing orders on the subjects are deemed to have been amended to the extent herein. So it does not mean 2002, it means
Yeah.
till that vacancy-based reservation was in force in Assam. And after the R.K. Sabharwal's case, the Assam government.
It became post-base.
Yes. So to implement the 2012 amendment was brought in. So my submission is that the contention of my learned friend that the 2002 got amendment is an absolutely a fallacious argument, because 2014 OM clause 14 in no way amends the 2002 OM. The 2002 OM remains in existence till date, because the 85th amendment has brought in the concept of accelerated promotion and consequential seniority, which has been upheld by the learned single judge. The single judge has rightly held that the benefit which we get, and when we go as a member of the unreserved class, when we go.
What did the learned single judge provide
Yes.
about clause 14?
Yes.
What is the views expressed on clause 14?
The learned single judge, this was not the contention, only the learned single judge gave its finding that clause 4, which was brought in by the OM of 16 by the Assam government, by which we were denied, the reserve were denied the benefit of merit. The court held that you cannot.
No,
do
that
it.
is another issue.
No, that is the issue on which appeal has been filed. Because what has
Oh,
happened,
then why was the argument
well, this
raised?
was an argument brought by my learned friend.
Not this side. Mr. Kane Chaudhary,
Yes,
not Mr. M.K. Chaudhary.
yes. But since he was
Although-
here that day,
Both of them have the surname Chaudhary. It's not Mr. M.K. Chaudhary.
Yes,
It was Mr.
sorry.
Kane Chaudhary who submitted that.
so Mr. Kane Chaudhary's argument was.
That I have recorded clearly.
Yes.
That was the only argument he made, that this clause 4,
Clause 14.
clause 111, 1.11.
Yes,
Which says they are not intended to determine seniority.
yes,
This, by implication, had amended the provision of consequential seniority of 2002.
yes.
This is precisely his
His
argument.
argument. And this argument is now.
So
found-
now we are testing,
Yes.
as this is the argument raised, we are testing the acceptability of that
Yes.
argument.
So.
And you confine to that?
Yes.
Why do you say something else?
No.
Again, he'll again go to say something different
Yes.
then.
My lord, his contention was that we are not entitled to consequential seniority
Because it has been,
because it
because
has
of
been.
2014.
Yes. My case is that, my counterpoint is that.
No, we want to now hear from you.
Yes.
Does clause 1.11
Mhm.
takes away the consequential seniority bestowed by 2002? If it takes away, Mr. Kane Chaudhary is right. If it does not take away,
Well,
we'll hear you.
1.11, my lord, this is the second argument of my learned friend, that 1.1 talks about the roster does not give you a right of seniority. That is not our case. We don't want a seniority on roster. We want a seniority on the rules. Because cadre-based seniority, which was not given to us by the Assam government, and we challenged that clause, and that clause has been struck down. Our petition was allowed. So his appeal, he is harping that 1.1 talks about roster promotion where you don't get seniority. Well, I don't get seniority, okay, but I get seniority on the day I go to the cadre. I go to the cadre on a at an earlier point of time than the general, because I go by accelerated promotion. When I go by accelerated promotion, I come to the cadre, and the rules are very specific that the seniority will be cadre based. So if seniority is cadre based, at no point of time, the general never challenged my going up.
No, you are on different issues. We are specifically on the issue raised. See, we can determine any dispute on the issues raised.
Yes.
We can determine any dispute by expanding the issues as far as possible and whichever direction it is taken.
Yes.
We intend to follow the first one.
Yes.
Whatever is raised, we answer it.
Yes. Sir.
And he is raising, Mr. Chaudhary is very specific, saying that the last line of this page 45, they are not intended to determine seniority.
Yes.
Takes away consequential seniority of 2002.
Yes.
So you confine it to
Yes,
that.
I'm confining to that.
So now let us understand what is clause 1.1. Only then we'll get the answer.
Yes. 1.1 says These rosters are in aid to determine the entitlement of different categories with regard to the quotas reserved for them in matters of appointment and promotion. They are not intended to determine seniority in the cadre.
What does it mean? Let us understand, they give a meaning to it, that will be end of the purpose.
Yes. My lord,
If we give the same meaning, sought to be given by Mr. Ken Chaudhary, or we have to give a different
no,
meaning?
I have to give a different meaning for the simple reason that my seniority is assigned in terms of the Assam Engineering Service rules in place. And the rules are very specific as to the mode by which seniority is assigned. Seniority is assigned cadre-wise. Rule 24.
Mr. Das,
Yes.
you're missing out the simplest of the argument, which
Yes.
is very much in your favor. You are so well versed in this concept that you are missing out the simplest of the argument. Yes, Mr. Mojumdar, you are appearing for the department. You are appearing for the department. We'll hear you, don't worry.
Yes.
You will not be prejudiced, you don't worry. Are you appearing for the department?
Yes.
Let us hear you.
Yes.
Come to page 45.
Page 45.
And before that, you come to page 44.
44 is the 2002 OM.
Scheduled caste, scheduled tribe, government servants shall on their promotion by virtue of rule of reservation roster be entitled to consequential seniority. So
Yes.
this is a very, very explicit provision, unambiguous. There is no two different meanings to it. Come to 45.
Yes. Yes,
Read 111 straight away. 1.11
Yes.
in fact, not 111.
The appointing authority shall.
These rosters are an aid to determine the entitlement of different categories with regard to quota reserved for them in matters of
I've missed Manu.
page 45.
45, preparation of rosters under the heading manner.
Read 1.11, last one.
Oh, yes, 1.11, I'm sorry, I was reading
It can be
1.1.
11 or 11, whatever it is, but
1.1.
more correct way is, I think, 1.11. The after point, it cannot be 11
I
anymore.
was reading 1.1, that is why I had.
1.11. These rosters are an aid to determine the entitlement of different categories
Mm.
with regard to the quota reserved for them in matters of appointment
And promotion.
and promotion. So these rosters,
My lord.
because if you see the opening paragraph, it refers to some roster.
Yes,
These rosters are an aid to determine the entitlement
yes,
of different categories.
yes,
So rosters are an aid to determine the entitlement of different categories. General category, what is your entitlement, where you are entitled, which post you are entitled in the roster. Scheduled caste, what is your entitlement, which post you are entitled. This is the meaning. For them in matters of appointment and promotion. So this will be applicable to appointment as well as to promotion.
my lord.
Now,
Right.
they are not intended to determine seniority in the cadre. Means these rosters are not intended to determine seniority in the cadre. What is the relevance of this sentence? Answer you'll get in the opening paragraph.
Of this OM itself.
Consequent upon amendment to the Assam Scheduled Caste and acceptance of recommendations of one-man commission, White so and so with Harish Sonwal IAS as the commission to study, acquire quantifiable data on the backwardness of scheduled caste and scheduled tribes, their inadequacy of representation in government services and post and impact in overall efficiency in public administration. Now, listen a little slow. Following guidelines have been prescribed in order to, just take note of this word,
My lord.
in order to implement the post-based roster reservation. This is pursuant to a Supreme Court judgment that implementation the post-based roster system, meaning thereby, suppose roster 65 is a scheduled tribe plains. When that scheduled tribe plane will go out of that cadre, either by promotion or retirement, 65 will fall vacant. This 65 will be filled up by another promotion
Same
from a
category.
same
Same
scheduled
category.
tribe planes.
By replacement.
So replacement.
Yes.
This man gets 65.
My lord. No,
Okay. Now the roster is active up to say roster 81. All that it provides is that the scheduled tribe man will get the roster point 65, although roster 81 had been effected a little earlier to that. This man cannot stake the claim that I being 65 is senior to 81. This is the meaning. They are not intended to determine seniority in the cadre. This post-based roster filling up is not for determining the seniority. Only this much it says. The earlier provision of 2002, that explicit provision that consequential benefit seniority by a decision had been implemented, had not been affected in any manner.
by this.
So Mr. Kane showed his submission that this had amended the 2002. We are having a little difficulty in accepting it. Because that is specific, consequential, this is specific. If you fit into a particular roster point, by virtue of that roster point, you cannot claim any seniority over anybody. And reading 14 now is not a general provision. All existing orders have been deemed to have been amended to the extent herein. Not a general deeming provision. So the only submission before the court that this 1.11 had amended 2002. Prima facie, we are not finding it acceptable, subject to what you say and subject to what Mr. Das says, subject to again what reply they give.
My lord, my argument.
So that's why I pointed out, Mr. Das, these matters have gone so deep. Everybody is so well versed in the law. You tend to go on the more complicated arguments rather than keep it in the most simplest of the form. First, let us have this, then we'll hear all other arguments.
My lord, before I give my reply to this, I've got one more submission to do. Pursuant to the judgment which is under challenge in this writ appeal, the government of Assam has published another notification.
2023.
2020.
That will consider separately.
No,
We don't want to mix up
No,
this
no,
one with that one.
I'm not saying it should be mixed up. What I'm saying is, my lord, they are taking a liberty of the judgment of liberty given to the government in the judgment of Honorable Justice A.D. Chaudhary. The government has issued another notification. with
Mr.
regard to-
Majumdar, you don't need the liberty of a court order
My lord,
because 85th amendment is very clear.
yes,
It
they are
is-
always,
it
always
is-
at
It is
liberty.
only an enabling provision. Government can anytime act in one
Take a call
manner,
and
at any time act in the other manner.
yes, take a call and since.
So you
it's a
don't
matter of
need
policy decision,
liberty given by any court for that
anyway,
purpose.
I'm just
It's a
saying,
constitutional
they,
entitlement.
but they have mentioned in their OM that since they have been granted the liberty, etc. But otherwise, your lordship is correct, my lord.
It's
It
a
is always
constitutional
open.
entitlement. You can do it at any time.
It is always open for the government. These being a matter of policy, if the government takes the
So
policy, they can take.
liberty is inconsequential.
Inconsequential, all right.
Had
What-
the liberty not been given, still you could have done it
Right.
if you wanted to do.
Now, if by either by the liberty or otherwise by the liberty given by the constitution itself, the government of Assam has now framed a policy and which is under again challenge, of course, but then they have taken a policy.
That's why I told you beforehand, we have
Yes,
seen the files.
yes.
That challenge is there. We'll deal with it separately.
My lord, I'm
We
not.
can't mix up with this item, item 33 read appeal.
Lord, will just permit me to come. I'll give a reply to this, man. I'm just thinking aloud what I'm otherwise thinking, man. There, the government has taken again a policy decision with regard to this constitutionality, the issue which we are now, my lord, deliberating upon. Now, whether, my lord, this issue again decided in this will have any bearing on that.
No, Mr.
This is one
Moginder,
aspect.
we understand what you are thinking.
Fine.
Suppose we decline to decide this read appeal at item 33,
Mine.
merely because in January, February 2023, the government has come out with another OM or another notification withdrawing the entitlement of consequential seniority. If that is the reason not to decide this issue, a further issue will remain. What will happen to the in-between period? Between 2014, when this
Yes.
OM of 2014 was issued,
That
and
issue will-
2023, when
Lord,
this
yes,
was.
correct. Yes.
So here
To
is
that
a
extent. man,
decision that is required,
Right.
whether 2014 had
date,
actually
yes.
amended 2002 or not.
Correct.
If 2014 had amended 2002, then from 2014, you don't have consequential seniority.
Correct.
Everything what happened subsequent it will have to go.
Yes.
If we interpret 2014 not to have amended 2002, then consequential seniority will remain up to 2023 or up to at any point of time in between if it has been actually taken away.
To that extent, it may be. Yes, I accept.
So,
All right.
so you answer on 1.1, that's a good enough.
Mal-
If we read that this has amended, it's well and good.
But so far,
The from 14 onwards, there is no consequential seniority. If it is not amended, then it will remain.
my lord, my submission so far as this question raised by my learned friend is concerned, my lord.
Which of the learned friend, Mr. Das or Mr. Chaudhary?
Mr. Das.
Das, okay.
Mr. Das. And here, if your lordship sees this page 45 poem of 29/4 December 2014. This was under challenge by the Equality Forum earlier, and this has been set aside.
This has been set aside.
Yes, ma'am.
Huh.
This was set aside, directing the government to do the exercise afresh. And they have done the exercise, then OM of 2016 was brought in.
So that has retained finality setting. aside.
Yes, yes, my lord.
So we don't read this
No,
one
my
anymore.
lord, that is what I'm saying.
So if it is, does not exist, the argument of Mr. K. Chaudhary also is,
I don't know.
does not exist
I
anymore.
don't know my lord, from what angle they were arguing, but then
No,
the page 53, my lord, will kindly see.
angle we can't change, we have judicially recorded the
My
submission.
lord. My lord,
Then
page,
you have to file an IA to withdraw that order.
my lord, page 50 is that OM of 2016.
Hmm.
Which has come in.
Page
place of-
number
Page 50, my lord.
50.
50.
Okay. Huh.
And everything in the first paragraph itself, everything is recorded, even this OM.
Hmm.
I'm reading my page 50.
Hmm.
As per, when this is an OM of 3 August 2016, which was challenged both by Equality Forum represented by my learned friend, Mr. Chaudhary, and also my.
So was there just one clarification.
Madam.
What was challenged in that writ petition from which this appeal has arisen?
But there were two challenges. I'm making it clear. There were two challenges.
Huh.
Equality Forum, which was represented.
No,
by-
no, in this writ petition resulting in the order in the challenging in the writ appeal, what
Yes.
was challenged?
Madam, that's what I. Madam, there were two sets of writ petitions. And both these writ petitions were disposed of by same order. Challenge number one,
Where is that order of the learned single bench? I think around 189, something like that.
page 152,
150.
page 152,
152.
page 152.
150.
Lordship will find,
That's a number of petitions were there.
yes, Ms. Man. So basically, two issues were there, my lord.
Hmm. These two writ petitions, 5026, 5005.
5005, 5026.
What was challenged in 5026?
Well, I'm coming to it. So these two writ petitions were picked up because in 5026 filed by Equality Forum, the challenge was to the very policy of reservation for promotion. The reservation in promotion for the reserve category was under challenge in 5026.
Okay. Then you cannot have any reservation in
Yes.
promotion. Very well.
Had this petition been allowed, there was no question of any
No,
constitutionality.
how was that issue decided?
That writ petition was dismissed. The contention raised in that petition was rejected, holding that we are upholding the decision of the government to have reservation in promotion.
With at least 2002.
Yes, this by the judgment.
No, by this judgment,
Yes.
2002 was upheld.
No, it only simply said that
Then what was upheld?
2016 OM, this page 50. Yes, yes. Yes, yes.
What yes?
Yes.
I'll have to clarify.
No, no, let me first complete, then my Maran.
Okay.
This
So,
OM
so
this-
page 50 was
under
upheld.
challenge. In this, my learned friend, a present man, your lordship can confirm.
No. Mr. Mojumdar, we don't doubt anybody.
My-
We believe in every
my
word
learned
the
friend is
learned
doubting.
council says.
My learned friend is doubtful.
We have to doubt him.
He is doubting.
Oh, he is doubting. It's up to him.
That is why
We
I
don't
am
doubt.
trying to affirm my lord.
We don't doubt.
So in this writ petition, the entire OM was under challenge.
So in 5026, OM dated 3rd August 2016 was under challenge.
Yes,
Okay.
that contention was rejected. And they have also filed an appeal challenging this. That appeal is
Where
pending.
where is the appeal?
239, item number 39, 38,
Item
item number 38.
38. 38 is also an appeal.
Yes,
So 38 and 33 has to be heard together
yes,
because two different writ petitions
yes,
and one writ petitioner is IV Gohai Dasgupta
yes,
pertaining to 5005.
yes.
What was challenged in 5005?
In that case, my lord, they have otherwise, my lord, supported the reservation policy, but they have
They means who filed that petition?
Bhagwan Patar,
Bhagavan Patar,
yes,
your client.
my lord.
So Bhagavan Patar had challenged,
Challenge-
what did he
One
challenge?
particular clause which says that constitutionality is not there, it is the catch-up theory.
Which clause?
Clause 4,
Was 4
At
of that
page-
16 OM.
my lord, my lord.
Okay, if occasion arises during the promotion in which
Stipulated percentage in respect of the reserve category is met, but in the gradation list, seniority list, there are candidates of reserve category who on merit is entitled to the promotion. His her case shall be considered for promotion on merit if such candidate has not gained the seniority by way of an accelerated
Okay.
promotion earlier.
So
Catch up,
a given candidate
my lord.
by accelerated promotion availed the benefit and was promoted.
You will be considered,
In the promoted cadre,
my lord.
the person is now entitled to further promotion on merit.
Yes,
So this clause says you cannot go to the merit stream once again. You have to remain to the reserve stream. Yes, that's the meaning.
my lord. Says my lord, you can compete, but not as a, not the constitutional seniority you will cannot enjoy.
No, nothing.
Well, that is why my land friend challenged this.
No, the seniority is not stated, just read it.
My
If an occasion during the promotion process in which
Yes.
stipulated percentage in respect of reserve category is
Is
met.
met.
So in a promotion process,
Yes.
the percentage in respect of reserve is already met.
Met.
It is over.
My
You
lord.
don't get a promotion as reserved anymore
Absolutely.
because the quota is fulfilled.
My lord.
Then, but in the gradation list, there are candidates of reserved category
Yes,
who on merit is entitled to promotion.
Yes.
That is without help of the policy of reservation.
reservation, yes,
You are entitled on merit.
yes. His
It
case
is shall be considered on merit
promotion
promotion
on merit,
on merit if such candidate has not gained seniority by way of accelerated
Yes.
promotion.
so,
Means while entering that cadre,
yes,
if the person had availed the benefit of accelerated promotion, even if you are on merit, you will not be considered. But if you have earlier promotion, if you have not availed the accelerated promotion, you can be considered on merit. This
Yes.
is the only meaning.
man,
There is not ambiguity at all.
no ambiguity, man. So it says has not gained the seniority by way of any accelerated promotion.
Has not gained
I can be
seniority,
sure.
definitely by way of accelerated
So
promotion.
what possibly, the language is such that it become slightly.
It is your language.
My language.
So what can you do?
I had the occasion to meet and discuss with the author of this also, that I cannot share here. But I had the occasion to discuss with him. What I have understood from here is the seniority he has gained because of his accelerated promotion. Because he, being junior to a general category candidate, got the promotion earlier. Now, if the seniority.
Accelerated promotion
My lord.
and seniority, they always go hand by hand.
Absolutely, my lord. Provided.
Suppose
My lord, provided.
from the original cadre,
My lord.
a man, why does he need accelerated promotion? He is junior to a particular person X.
Exactly.
He gets accelerated promotion.
Right.
In the next cadre, he enters first, then the person X.
Yeah.
So definitely when X enters that cadre,
Yes.
he will be senior to X because he has already promoted
Yes.
into that cadre.
My lord.
So now seniority is an accelerated promotion. They always go hand in hand.
My lord, here I have got
There,
one submission.
unless you deny consequential seniority.
Yes, my lord, that is my.
Specifically,
Exactly, my lord.
this seniority is retained,
Exactly.
but consequential
As your
seniority denial, that decision also has to be explicit, clear, unambiguous,
My lord.
so that no two meanings can be given
Absolutely.
to it.
My lord, absolutely.
And
Here,
clause 4 does not give any such meaning,
my lord,
if you read it.
my lord, clause 4 was understood by them also to be carrying a meaning that if you have been promoted earlier than a general category candidate because of your reservation,
But
then
Mr. Mojumdar, a court of law, just because two parties understood it differently,
then no, never.
we also cannot understand
No,
it
you're
the
not.
same different
No,
way.
I'm not saying that. What I'm saying is, my lord, what this clause says is that if a reserve category candidate being a junior to a general category candidate gets a promotion earlier in point of time, just give me 1 minute, I'm just trying to make it a point. Earlier in point of time, but subsequently, if the general category candidate gets promotion to the same cadre, and the question comes to determine their seniority, if consecutive seniority is followed, then reserve category will still remain senior. If catch-up theory is followed, then the
Here
senior.
gets back his original seniority.
Yes. So the question came, what is the criterion for determination of seniority, whether it is catch-up theory or consecutive seniority? But this, when it says that if you have got the promotion earlier by virtue of your being a reserve category candidate, then subsequently in the promoted category rank, your promotion, accelerated promotion you might have got, but seniority will not get. This is what it says.
No, it does not say that.
My lord, should kindly see
It
one
does
thing.
not say it. You read it.
Well, I'm still reading the last part. If such candidate has not gained the seniority by way of any accelerated promotion.
Means dominant purpose is accelerated promotion.
Yes.
If you had the beneficiary of an accelerated promotion
And
and
seniority.
for further promotion,
Yes,
your quota of reservation is already filled up,
my lord.
then if otherwise, even if you are the best eligible candidate on merit,
Right.
you cannot switch over to the merit stream and claim now promotion on the basis of merit. This is the only meaning you see. I don't know how your people worded, but the wordings gives that to be the only meaning.
My lord.
What to do?
My lord, I'm just, for me to make submissions, your lordship will decide. My lord. So my submission before your lordship is, it says that has not gained the seniority which he has gained by virtue of his accelerated promotion above the general category candidate who was senior to him in the feeder cadre. That seniority that he has gained.
Mr. Mojumdar, we understand what you are trying to
My
say.
lord.
It's not that we are not understanding anything. But that kind of a meaning is not discernible from this clause.
My lord, had,
That is the difficulty.
my lord, my. if
And
we-
is there any proposition of law that the underlying reasoning of an authority gets precedence over what is reflected in a provision? Other than that concept of not happily worded. Not happily worded is something different.
My lord, I'm-
That it could have been better placed. But
Yes.
having placed and giving a different meaning, can we abandon the meaning apparent on the provision and adopt a different meaning because the underlying purpose was different. I don't think there is any such provision.
This 505 writ petition
Hmm.
was challenged by them on this count only, that this says catch-up theory and not consequentiality.
They understood wrongly.
They understood.
Let me clarify, you wrongly understood it.
Yes.
End
So,
of
my
it.
lord, my further submission, my lord, I've got my further submission. And this is there. My lord, my next submission is, my lord, when this 2014 OM was under challenge in Equality Forum, earlier round of Equality Forum case, this 2014 OM was set aside.
Hmm.
The government of Assam was given the liberty to decide as to whether they would like to have reservation in promotion or not.
Consequential promotion, you want
No,
to,
consequential.
no, for reservation promotion.
Yes,
You decided.
my lord, the government of Assam was given the liberty to decide as to whether they want to go with reservation in promotion or not. My submission here is, my lord, when assuming that 2002 policy remains till then, till the judgment passed in Equality Forum case in the earlier round of litigation is concerned, remains, my lord. Moment the Equality Forum judgment was given by Honorable Justice, the then Honorable Justice Ujjwal Bhuiyan, that
Don't-
I'm
don't-
setting aside.
No, don't take the
No,
name.
my lord,
It's
if-
begun by the court. Huh.
My lord, or this honorable court set aside this 2014 OM and remanded the matter direct to the government of Assam.
Very well.
Take it.
We understand. 14 was set aside.
Set aside.
Huh.
My
So
submission-
remanded back that
Yes.
you take a more clear, unambiguous decision
Correct.
whether you want to
Yes.
retain promotion or you don't want to
Yes,
retain.
in terms of.
Because under the 85th amendment and other is 82nd,
77 and 85.
77 and 85th,
Yes, ma'am.
you retain a power and authority
Because
either
it's
to
a-
give reservation and promotion or not
Yes.
to give. 85th, in addition to that, either to give consequential seniority or not to give.
My lord. Absolutely.
That's a constitutional power.
Yes.
So
No, well, I'm,
you
my,
exercise your power, take your decision.
but I've got my further submissions, but you kindly bear with me. My submission, my lord, before the honorable single judge in this case was, this case was, that when the government, this honorable court sets aside 2014 OM and directs the government to take a call as to whether you will have reservation in promotion as a matter of policy or not. That means the liberty is given to us to decide. Supposing we decide not to give any reservation in promotion, whether this 2002 OM will remain or not, my lord. That was my question to the other side.
It will go. You don't have to ask them. We
My
have to
lord,
ask them.
that is my only submission before your.
So provided you had taken a decision
My lord,
not to give reservation in promotion, where is that
my
decision?
lord, I'm coming to that. I'm coming. Lordship will kindly bear with me.
If you had taken a decision,
My lord.
definitely you are right. That will have a overwhelming effect over the 2002 decision and
Yes.
also some earlier decision
Yes,
to give reservation in promotion.
yes. Now, my lord,
Provided that decision is taken.
my lord, I'm coming to that. My lord, now, when we take a decision to provide for reservation in promotion, we have to take a further decision as to whether for the purpose of determination of seniority, we will have catch-up theory or consequential seniority. This is again a second exercise.
Hmm.
Your lordship once heard in.
See,
series of
one is
this question also.
77th amendment and other is
No,
the.
No, my
85th.
lord, there is one more issue. This 77th amendment simply gives liberty to the government to take a policy of reservation.
Huh.
This 85th amendment says
Consequence.
whether consequentiality you want to give,
That is
we
not
can
clear,
give,
sir.
my lord, government can provide for reservation and promotion without consequential seniority
You can
or
do
with.
that.
Or
You can do
consequential.
that. See,
So, my lord,
see,
my-
all the possibilities are there. You will have reservation in promotion
without consequential seniority.
with consequential seniority. Let us start with
My-
in the descending order.
My-
You can have reservation in promotion without consequential seniority. You cannot have no reservation in promotion, but consequential seniority, that is, cannot be conceived.
No reservation, yes, ma'am, yes.
That cannot be
That cannot be
conceived.
conceived.
You also have the fourth option, not to have anything at all.
Anything.
Ah.
Now, when 2016 OM was brought in compliance of the action of the Honorable Court in first writ petition of Equality Forum, my lord. Then this-
So if you are repeating the expression in compliance of the court order,
my lord,
are you to understand you are exercising the jurisdiction given by the court or you are exercising jurisdiction under
Only-
77th and
only-
85th amendment?
Only for the purpose of saying that 2014 OM has gone and we had the liberty to take a fresh decision, this much, for this much only. Not for any other purpose. So 2016 OM, when it was issued, my lord, we, in my humble submission, my lord, by first sentence of Lordship, may kindly see page 50 for a moment.
In Nagraj, UP Power, Government of Assam prescribed procedure how to
page-
implement policy of reservation.
My Lordship, may kindly see page 51 for a moment. Page 51.
Yes, please continue.
My lord, I would like to read from page 50 onwards. This order went to OM, I want to read, man. Page 50, man. Review of government policy of reservation in promotion with preference to, it should be, with reference to the Honorable Guwahati High Court's judgments. As per guidelines laid down by the apex court in WBC number so-and-so, M. Nagaraja and others versus Union of India, and in CA number so-and-so, UP Power Corporation Limited versus Rajesh Kumar and others, the government of Assam have prescribed procedure as to how to implement the policy of reservation in promotion by OM number so-and-so, dated so-and-so. The report of the one-man commission on quantifiable data was accepted by the state government with the approval of the state cabinet. Accordingly, on the basis of the report, the government decided to provide reservation in promotion. These provisions for reservation in promotion were also incorporated in the aforesaid office memorandum. However, the report of the commission was challenged in the Honorable Guwahati High Court by Equality Forum in WP number so-and-so. The Honorable Court observed that though state has made provision for reservation in promotion by enacting the 1978 Act, which was amended in the year 2012, implementation of the same would depend on acquiring of quantifiable data with regard to the two compelling reasons, which exercise has to be carried out cadre-wise in the context of the service where the cadre is placed. That having not done, the report of the one-man commission would be of no legal consequence and would not enable the state to give effect to the provisions of 1978 Act, as amended insofar as reservation in promotion is concerned. That was a quotation from the earlier judgment. Then comes next paragraph. The government of Assam, after careful examination of the observations of the High Court contained in judgment dated so-and-so, have come to the conclusion that the High Court has not set aside the government policy of reservation for reservation categories in promotion. Rather, it strikes down only the basis on which this policy was adopted.
It will be for the best interest of everyone if some peculiar sounds are not made through the mobile phones.
Absolutely.
No, somebody is making something. Please stop that. Whosoever is doing it.
This has not ended the continuation of the government policy on reservation in promotion. In its ruling, the Honorable High Court stressed that paragraph 74.
We're reading page 51.
Page 50, madam. Page 50, the last paragraph.
Huh.
Para 74 of that judgment manual is quoted here. It is reiterated that if the state desires to give effect to the provisions of the 1978 Act as amended in the year 2012 by providing for reservation in promotion, it would have to justify the same with the help of quantifiable data to show preference of presence of two compelling reasons, backwardness and inadequacy of reservation. Cadre-wise, in the context of the
No,
service
Mr.
where
Majumdar, we are very tempted to ask you one thing. If the entire judicial thinking was that quantifiable data and that adequate representation was not taken into consideration, this directly hits at the adoption of the policy of reservation in promotion. Okay. Vis-a-vis consequential seniority, if agreeable. So if this is the judicial view, 2002 ought to have been set aside. which provides for reservation in promotion plus consequential benefit. Why was 2014 set aside? 14 is on a totally different context. 14 says this reservation will be as per the roster point in the roster. The example I gave, the 65 and 81. That's the only provision of the 2014. 2014 neither provides for nor takes away reservation or consequential benefit. So if the underlying judicial reason is quantifiable data is not there,
Yeah.
what ought to have been interfered is the 2002, not 2014.
But this,
By allowing 2002 to remain
my lord,
and interfering only 2014, maybe it is an advice from the court that you re-exercise your power under 77th and 85th Amendment,
again,
whether you want to give or not, but 2002 remains in place. So, mind I used one word in the very beginning, it's adding to the confusion. If at all the reasoning I accept, it's a very good reasoning.
my lord.
There is a requirement of there being quantifiable data. Quantifiable data was not appropriately obtained. So you, without doing it, you should not have done it. Why interfere 2014? Either you interfere 2002, that as if it is not there, now you take a decision. Or you don't interfere 2002, let the decision remain. First you take a fresh decision, and that will prevail over the earlier one.
My lord,
Either of the two provisions, there is
my lord, but possibly two things happened. First, this 2014 OM itself was under challenge. 2002 was not under
so
challenge.
therefore I am saying, what does the 2014 provide for? It only says it will be post-based reservation as per the roster. Means theory of replacement.
Replacement.
If the man at roster number 1 is, I think, scheduled caste, I think. If the man at roster number 1 retires or get promoted, that roster number 1 gets vacant.
Replaced
He
by
will be
same-
replaced by another
Same category. person.
of the same category. This is all it provides.
Yes,
Why do you set it aside?
then I'll have to read this 2014 OM also. What was it for?
No, we have read it.
My lord.
And there one provision is there, clause 1.11, that this provision will not confer any seniority. That's all. Nothing beyond that. It doesn't touch on upon the question of law of reservation and consequential seniority. But anyway, rightly, wrongly, it was set aside. It goes. So point-based replacement is goes. It is not there now. Because 14 is set aside, he said.
No, it's a wrong submission because I'll show from the judgment. 2014 was never set aside. In Equality Forum judgment, possibly para 54, the learned single judge clearly says will not touch that because that is only
So
for
14 remains.
implementation of force-based.
14 remains.
Yes, remains.
Okay,
So
fine.
that submission is wrong.
So 14 remained. All that the court required is
Because-
to undertake a fresh exercise now. Depending on the availability of quantifying data,
Yes, that
whether
was
you
the
should have reservation, you should not have,
And
whether
in
you
fact-
have consequences or should not have.
And in fact, in 2016.
In fact, for this, you don't need a court power. 77 and 85 amendment is already there. It's a constitutional power.
Yes, in fact, in the 2016 OM, it makes that the government of Assam, after carefully examination of the High Court order of Equality Forum, has come to a conclusion that the High Court has not set aside the government policy of reservation for reserved categories in promotion. Rather, it only struck down the basis on which the policy was adopted. This has not ended continuation of the government policy of reservation in promotion.
And that is also difficult to accept.
what
If
is-
the basis is struck down, that
Yes, yes, it
decision
is
also
what I
goes
wanted to say.
otherwise.
This judgment clearly
in
says.
fact-
You can't retain the first floor of a building by taking away
Yes, yes,
the
so by
ground floor
the-
and the foundation.
By this judgment, the first Equality Forum judgment, the ground floor was demolished. saying that the Sonwal commission report, one-man commission report of Sonwal, based on which this OM of 2014 came, is satisfied. My lord, I'm just reading this line. It says like this manner, that having not been done, the report of one-man commission would be of no legal consequence and would not enable the state to give effect to the provisions of 1978 Act as amended insofar as reservation promotion is concerned. So the basis was removed by the judgment. So nothing remains in the submission of my learned friend that this is not correct, and this 2014 OM remains.
No, 2014 remains.
My lord,
The basis of reservation
my lord,
goes,
2000
but the 2014 does not provide for reservation.
Absolutely. My lord, that is what I'm saying, my lord. 2014 OM otherwise is for implementation of post-based reservation. But lordship will kindly see the first three lines. Consequent upon the amendments made in the Assam Scheduled Caste and Scheduled Tribe reservation vacancy in the post 1978 and acceptance of recommendations of one-man commission.
There 14.
My lord. This was
Difficulty is, Mr. Mojumdar, you start from Chanmari with the intention of going to Panbajar. Around Guwahati Club, you take a left turn, take Bureau, go to Dispur. That is the difficulty. You started somewhere in some direction, deviated, went somewhere else.
And you
Now,
wanted,
what will we decide now?
you
Tell us.
wanted to reach some destination, you reached another
Something else. Now, which one to go?
That is
If
the
you
problem.
go by the basis, the destination where you initially intended, we have to look into.
It goes.
That basis goes, but the difficulty is ultimately you went somewhere else. That somewhere else is not illegal in any manner.
Yes.
Let us sort it out, what to do finally, tell us. That there'll be even playing field for everyone. Do it.
If I may, lordship allows me to read one operative part of the judgment where the query of.
That
clause four,
equality judgment.
No, the latest judgment.
The judgment under
single-
challenge is.
After learn single
Which
yes,
allowed our.
yes.
Well, if your lordship takes up page 189,
What is
where
it?
a summary is made about how the learned single judge comes to a conclusion that clause 4 of the 16 OM is ultra bias, it's not in terms of the Supreme Court's order. So
Clause
if I may
4.
read.
Clause 4 of 14.
Yes, yes, because my entire challenge was
Clause 4 of 40 or 16?
60, not
16.
14 I cannot challenge because that is
Ah,
post. So if I read that, lordship, allow
Please, wait.
page 189, lordship.
Uh,
Whether clause 4 is violative of section 5 of the 78 Act and therefore liable to be struck down. This is the finding and the ratio of the case. Clause 4 of the offending office memorandum provides that in a given situation when the percentage earmark is achieved, but some reserved category candidates who on its own merits are entitled to promotion, his and her promotion shall be considered on merit, subject to the further condition that the said person has not gained any seniority by way of accelerated promotion. Thus, from a reading of clause 4, it is clear that consequential seniority is withdrawn for those persons belonging to the SC and the ST who are eligible for promotion on merit but has got accelerated promotion. The said clause nowhere declares that the policy of consequential seniority shall henceforth not be applicable to all the promotions made under section 5 of the 78 Act, which your lordship has rightly held. Yes. That being the position, this is the ratio, the court unhesitatingly holds that the policy of providing reservation in promotion with consequential seniority being holding the field as per the OM dated 12/3/2002, the state is not within its competence and jurisdiction to deprive such service benefit to a meritorious reserve category candidate, and that too without expressly bringing such a policy by superseding the benefit granted under OM dated 12/3/2002.
So now we put a fundamental question.
Yes.
Learn single judge that paragraph D, that Roman 1, no difficulty in accepting it.
Yes.
This is basically describing what is provided in clause 4.
Yes.
2 creates a problem.
Yes.
it is clear that consequential seniority is withdrawn for those person belong to scheduled caste.
Yes.
It does not provide so.
Well,
Clause 4 does not provide so, other than the manner in which Mr. Mojumdar seeks to
Yes.
give an interpretation. Think that this was the basic idea in our mind.
Yes.
3 is even not acceptable. That being the position, this court unhesitatingly hold that policy of providing reservation in promotion as a being holding 2002, state is not within its competence and jurisdiction to deprive such benefit to a meritorious reserved category.
Yes.
Now the question is, if we consider only clause 4 as it is,
Yes.
clause 4 says that if a reserved category candidate was the beneficiary of accelerated promotion while entering that in-between cadre from where he wants further promotion, then in that in-between cadre for further promotion, even if he is otherwise eligible in merit, but there is no quota left for him, he cannot be considered.
Yes, means he cannot.
Now, in otherwise, we are borrowing the concept of a reserved man, if otherwise eligible in merit, should be considered on merit.
Yes.
Whether that principle is applicable also for a promotion.
Yes.
Because ex officio, that's a principle of direct recruitment.
Yes.
Whether that principle has also ipso facto applicable in a promotion.
And also.
So this is the issue where we
Yes.
have to go
And
in.
R.K. Sabharwal is very specific, para 4. The Supreme Court says that when we go as a member of the, on merit, we go as a member of the unreserved, the prescribed percentage is unaffected. We go on merit, but the clause 4 put a spanner on us.
No,
And
clause 4 does not put a spanner on those persons who had taken the merit path all along. Clause 4 puts a spanner in those who had not taken the merit path but the accelerated path.
yes,
In between, in between cadre, they suddenly become meritorious and now want to switch over to meritorious and now take the other route also.
but by applying.
There's a
this
difference
clause-
between the two.
Yes, by applying this clause, we lost all our seniority.
No.
That is the reason. That's the reason we
No,
approach
no,
this. court.
no. Seniority we uphold. Whatever seniority you have attained, you attain. As long as consequential seniority is there,
Yes, no.
You
the
retain your
Assam
seniority,
government did not
but-
deprive.
but you cannot compete on merit. I think this is the only way we see it.
Yes. That is clause 4.
No one has taken away your seniority.
But we lost our seniority, so only we approach this court.
On facts, if you have lost, if not taken away, we deal it with separately. But-
This is the case.
But on law, no one has taken away your seniority. All that clause 4 is taken away is if there is no avenue available in the reserved category line because it's already filled up by somebody, you cannot, by merely claiming merit, you may be the best of the meritorious person. You cannot now switch over to the merit side and now say, give me your merit.
But now.
This is available only for direct recruitment at the initial stage. Not at a subsequent stage where benefit of reservation had already been availed.
But in the
for the
actual
earlier
report, what
promotion.
had happened in all promotions on all the 60 departments of the Assam government, they have brought all the reserves seniority down. That's the reason we have approached.
So we'll interfere with that.
Yes, they brought us down
See,
for no fault of us.
there is a difference between bringing down your
Yes.
senior consequential seniority and giving you the opportunity, not giving the opportunity to avail further promotion on the merit stream.
In fact, Lordship,
Those are two different aspects.
Lordship, what has happened of this petitioner, Ivy Guha, she retired 1.5 years earlier. But my client, who lost his seniority because of clause 4, is still there in service. And I am told that he is selected now to be the chief engineer for first.
If you're selected, you're otherwise eligible, you get promoted. No one is stopping you.
That was the reason we challenged it.
No,
From 20, we were deprived.
Mr.
That's it.
Majumdar, law is quite clear. We don't see, yes, Mr. Chaudhary will hear you. We don't see any clause 4 bringing in any aspect where consequential seniority has been taken away. All that it provides is if while entering that intervening cadre, you have availed the accelerated promotion by law of reservation. and there is no further quota available you for further promotion on the reserved line, even if you are the most meritorious, you cannot come and compete in the merit stream. That's the only restriction that is placed.
Madam, my submission will be like this, madam. I'll just read that particular half of the sentence again. If such candidate has not gained the seniority by way of any accelerated promotion.
Yes, so
What in my humble
go,
submission,
no,
madam.
go part by part. If that person has not got accelerated promotion, we understand this man, if had not got accelerated promotion, he belongs to a reserved category. All along, he is competing on merit. He will be also entitled to compete on merit in this particular promotion.
My submission is slightly different. What in my humble submission, subject to what your lordships ultimately hold, madam, is this, that this sentence means that you can always be considered on merit, but this seniority which you have gained by virtue of your,
How can you put in words?
this is
How
what
can
is,
you put in some extra words and give it a different meaning now?
because my lord, at that stage, at the time of hearing of this petition, when the government was asked to file an affidavit to clarify further, because this was taken into consideration, and this one court directed the government to file an affidavit saying, what is your policy? The government filed an affidavit saying that we
No,
are.
After having provided for it,
Madam.
and that provision carries a totally different meaning. Can you clarify and say that no, this meaning is not that, it is something different? Tomorrow, can the legislature, to the secretariat of the legislature, ever file an affidavit that this statute, although it means X, but we all along meant it to be Y? If you have noticed, you amend it. If you have noticed that whatever was intended is not forthcoming in a given provision, you can always amend it. You can withdraw it at any time you feel like. But how can we give it a different meaning? We are asking you on a principle of law. Suppose we accept this on principle. This will be applicable to everywhere,
Yes.
every statute. Tomorrow, the Union government may come and say that 302 was intended to be in this manner, not in the manner it is provided there, IPC. What will you do?
Language is different, but what the government also meant is that accelerated promotion, but not accelerated seniority.
Yes. That is the issue.
How can you put in words that I think interpretation of law does not permit you to do that? This is what we are trying to ask you. Do you have any proposition which may allow you to add in a few words to give a meaning little different? If you have, we'll definitely consider it.
Well, if you we read the whole sentence, Manoj. If an occasion arises during the promotion process, I'm reading it again. If an occasion arises during the promotion process, occasion arises.
Occasion
in-
arises
yes,
in promotion.
in which stipulated percentage in respect of reserve category
Is
is
met.
met.
So there is
That
no
means
further quota
no
available for
reserve,
reserve.
Yes. But in the gradation list or seniority list, there are candidates of reserve category who on merit is.
Who on merit is entitled.
Yes,
So this man may be the most bottom of the list, maybe in the top of the list,
Yes.
maybe consequential seniority, maybe without consequential
Yes.
seniority. But he deserves only on
That's not the end.
merit.
yes. Shall be considered for
Ah,
promotion on merit
This is what we are saying.
if such candidate has not gained the seniority by, that means minus the seniority, you can be considered on merit.
No,
Yes.
But that was, on that basis,
this is
promotions
what we are
were,
having.
my lord, on that basis,
No, you
promotions
would-
were
you-
given,
You
even to the reserve
you-
category.
you withdraw this and clarify it. What stops you?
No, my lord, can I just come in, my lord? This
He
is the
is
point
just a
which.
minute, who on merit is entitled, his her case shall be considered for promotion on merit.
Yes,
If the candidate has not gained,
yes.
what?
So that it doesn't say that he will not be considered, he'll be considered.
Hmm.
He will be, and in fact, my lord, government considered also those persons, not that they were deprived. My learned is not
So
clarifying
if he has not gained seniority by way of,
accelerated seniority,
Promotion.
accelerated promotion.
promotion, I'm here,
Promotion.
accelerated promotion, I'm
So,
sorry.
so consequential seniority.
Yes,
Yes.
that was only negated. Otherwise,
So if you have not got consequential seniority, you will be considered on merit.
Yes.
If you have got consequential seniority, you will not be considered
In
on
other
merit.
words, his case will not be considered
But,
against the
but
general
that
category.
means consequential seniority remains. It has not been taken away.
My lord, can I explain, my lord?
Core submission was consequential seniority gone. Where is it gone? It remains.
No, my lord.
You only are recognizing it by your own interpretation.
No, my lord, there are two issues before your lordship. While opening the argument, I made this point very clear. One is, my lord, as my learned friend would like to, project, that even if to have reservation in promotion, you have to follow the dicta given by the Honorable Supreme Court. That is one aspect, which my learned
That
friend.
quantifiable data.
Yes, that my learned friend will deal with. I am dealing with the aspect of consequential seniority. Now, in Bhagavan Patar's case, the learned single judge has held that.
Bhagavan Patar had challenge clause.
Yes, no, we have, yes. No, my lord,
Okay.
we have challenged the judgment in Bhagavan Patar in IV Dasgupta's case. My lord,
This is what we are hearing now.
exactly. My lord, in that case, the learned single judge has held that accelerated promotion and consequential seniority are a natural fallout of Article 16(4)(a).
Where is it?
Yes, that is the judgment.
No,
Yes.
that has not been brought to notice.
Yes, I'll show, my lord.
On which page?
Yes, my lord will kindly take this IV Dasgupta's writ appeal 46, my lord. Please come to page 187.
187.
Please come to page 187. Please come to Roman 2.
Roman 2. It is well settled.
It is well settled that consequential seniority is a consequence of reservation in promotion and not an additional benefit.
Okay.
Article
Got it.
4A of the Constitution being enabling provision, state is at liberty to so and so. The next para. Kindly see the contradiction in these two para, my lord. Consequent to the amendment of Article 16(4)(a), the state decided to follow the principle of consequential seniority, which is reflected in office memorandum dated so and so. While office memorandum dated was notified, decision in Nagraj was not available. But
So
the
this is
policy of
correct. This is correct. 2002, they brought in consequential seniority.
Yes, they brought in.
Then after that.
Yes, but the policy of granting promotion in reservation with consequential benefit is expressly provided in section 5 of section 78. Read with notification. Where is this expressly provided, my lord?
Section 5. Let us read section 5. What it says.
No, let me read further paragraphs. my
No,
lord.
no,
Please
let
come
us
to
clarify this part.
Yes.
Let us read 5. What is it? Service.
187. My lord, the act
You are
starts at
holding, you are
251.
holding this one?
Yes,
Page number?
yes, 251. Reservation for members of schedule,
Section 5.
page 254, my lord.
Section 5.
Yes.
Reservation.
Reservation for members of scheduled caste and scheduled tribe in the post to be filled up by promotion in any establishment shall be regulated in the following manner. There shall be, it's a matter of the procedure. So where is it expressly provided? On the contrary, my lord, the amendment of
No,
2000
reservation for members of scheduled caste in post to be filled up by
by
promotion shall be regulated, there shall be reservation of 7%.
Yes, for
So
SC.
7% reservation is provided,
Yes.
provided the state government of time to time review the implementation of reservation and take adequate
Increase of
measures.
percentage
including-
mentioned.
So this is provided.
No, my lord, where is
That is-
that? The consequential seniority is provided.
Consequential is not
No,
there.
because, well, I am on that. The learned single just says that it is expressly provided.
It also added, understood, understood. Okay, fine. No.
My lord, as held by the learned single judge, if consequential seniority is automatic, why do we need 12/3/2002? We don't need.
No, that is okay. We agree with you to that
So
extent.
therefore, what we are saying is, my lord,
Hmm.
at that point of time, my lord, what had happened? If we go by the OM.
And this conclusion that was arrived at that Roman tree,
Yes,
what impact did it have on the ultimate decision?
now ultimate decision is, my
Or
lord.
it is just
Now,
a,
there will be not only, my lord, accelerated promotion, they will also be entitled to consequential seniority, meaning thereby they will go on, my lord, superseding the general category candidates.
so as long as 2002 remains,
Yes,
they'll go on getting it,
of course, that is there, my lord, that
Huh.
we are not disputing, but we say,
not by virtue of section 5,
not by virtue of,
2002.
yes,
Ah.
but what we say is, my lord,
Ah,
what was expressly provided in 2002
hmm.
has been impliedly done away with by 29/12/14 and 3/8/16. That is our case. The reason is why I'm telling, my lord.
14, I have already recorded your
Yes.
submission the other day.
Yes,
That clause 1.11.
yes.
Yeah, we'll give an interpretation.
Now, my
to
lord,
it.
let us
Now-
give
now
a
what-
meaning.
Now, what is,
Four.
what is the other provision you said, other than 14?
My lord, clause 4 of 3/8/16.
3/8/16. Huh.
Yes.
Now read, let us read
Yes,
3/8/16.
yes.
In what manner it takes away
I'm
consequential
reading it, my lord.
seniority?
My lord, may kindly come to page 52 of that written
52,
bill.
huh.
Yes.
No, this is the
Yes.
seventh or eighth time we are reading it, today itself. Yes, now we read according to you.
My lord, once my senior took me to Jagadesh Medi's place.
Hmm.
That was the time when he used to sit at an armchair. And my senior posed a question, asked a question to him. Then he answered it, then he told my senior, you read this provision as many times until you have a clear idea of what the provision contains. Don't count the numbers. I still remember that. My lord.
See, if you look at the rainbow, at times it looks red, at times it looks green, at times it looks yellow, everything it looks.
Sometimes, of
So
course,
more
my
and
lord-
more you look, it depends on where you were reading, looking at it.
Anyway, let me read it, my lord. Let me try to understand.
No, no, yeah.
If an occasion arises during the promotion process
Hmm.
in which stipulated percentage in respect of reserve category is met, but in the gradation list, seniority list, there are candidates of reserve category who on merit is entitled to promotion. His or her case shall be considered for promotion on merit if such candidate has not gained seniority by way of accelerated promotion earlier. My lord, after the roster points are filled up, in the, my lord, zone of consideration, there are reserve
Suppose
category.
for promotion from this cadre to next cadre,
X to Y.
four posts are available.
Yes.
4 posts are already exhausted.
Yes. No, roster points are exhausted. General seats are there.
No, general are there. For the reserve, 4 are there.
Yes.
All 4 are exhausted.
Yes.
Now there is one more general person.
No,
I mean reserve person. He is very much meritorious. He wants to compete on merit.
He's
So this man will not be considered for merit by also attributing the consequential seniority.
no, because he has earlier earned a promotion
No, if
or by roster. That is why he got that seniority. My lord,
so then he'll not be in the cadre at all, if you can take that view.
No, my lord,
But
he's
he's
in-
already entered the cadre, right? You're
He is
wrong.
in the zone. He is in the zone of consideration.
All that we can appreciate is for that available reserve posts are exhausted. The 5th reserve man is here now. Sorry. He wants to compete on merit. He can do it, but the consequential seniority that he had gained, that has to be abandoned.
If it is abandoned, then he is not in the zone.
If abandoning it, you are still entitled, you are in. But with abandoning, if you are not in the zone of consideration, you are out.
Yes.
I think that's the only
Yes.
meaning you
And
can
the,
give.
and the reasoning is 5A, section 5A. Please come, my lord.
5A
Because,
of the,
because reservation would operate by way of replacement. That is why. Please come to my lord, page number 255.
so So now minus the consequential seniority.
Ah.
If otherwise in seniority, he still makes it,
Yes, that is a different,
you are welcome.
but not by virtue of your accelerated promotion and consequential seniority.
Suppose
whichever.
the zone of consideration is that 4 senior most will be in the zone of consideration. By virtue of your accelerated consequential seniority, you are within 4. Minus your consequential seniority, you are out of the 4. In this
Correct.
case, you will be out.
Yes.
But without your consequential seniority, if you are still within 4, you can compete on merit.
Now, my lord, kindly compare this situation with the situation visualized by 12/3/2000. Why we are saying by impliedly it stands repeat? That is the reason. Now, if your lordships visualizes this situation with the situation visualized by 12/3/2002, then your lordships will find that impliedly it stands repeat. This argument of ours was not accepted by the learned single. No, it was considered rejected.
Where is the rejection?
Yes, ma'am. But before that, would your lordships kindly permit
No,
me
let
to-
us go point by point. We'll go.
5A is very relevant. One section, one provision, my lord, in the book, page 256. This is because.
This has come after the Supreme Court judgment.
No, my lord, this has come, yes, after Nagaraj judgment
Hmm.
in 2012, when amendment was made, these provisions were inserted. Whole 5A was inserted. The roster is to be operated on the principle of replacement and not as a running account. That means if you are SC, you can only go to SC post, you can't go to any other.
Very.
Now, my lord, will kindly come to the judgment.
Where is it said that it was impliedly not repealed?
Yes. Huh? What we say? My lord, sorry, learned single judge referred to my judgment, but learned single judge did not
Decide on it.
Decide.
Then we'll decide it.
Yes. My lord, the other day I gave one memo of, written argument. Is the lordship holding that, my lord?
Send it.
This is the copy.
Okay.
In a different case, of course, but same issue. It would WPC 1567 or the same. Look on us. Yes. Hey, Robana. Acha no job at issue too. No, I don't know. This can issue क्यों करना चाहते हैं? I'm confused. তাতো এই বহুত মাইনাস ব্যবহার করলো না কিন্তু আমার Would your lordships kindly come to page 7 of the written argument, my lord? Just 2 paragraphs I'll read, my lord. Please come to para Roman 11, my lord, at page 7 of the written argument. That it will thus be noticed that after issuance of OM dated 12/3/2002, which conferred the benefit of consequential seniority to the roster promotees, various changes have taken place in the legal scenario as explained herein above. By necessary implication, if not expressly, roster promotees not entitled to consequential seniority with effect from 29/12/14 and subsequent dates Now, following issuance of the OM dated 18/1/23, though Government of Assam has decided to pursue the policy of reservation in promotion in all posts, but in respect of Group A services, it has been decided that roster promotee on accelerated promotion shall not be entitled to consequential seniority. In other words, the OM of 18/1/23 recognizes the right of the unreserved candidates to regain seniority in the promoted cadre by application of CATSA principle. That in the circumstances, a pertinent question arises for consideration in the present list, that is whether OM dated 12/3/2002 lost its efficacy with effect from 29/12/14 when Government of Assam, pursuant to the decision in Nagraj, an amendment of the Act issued OM dated 29/12/14, wherein it was specifically provided that rosters are not intended to determine seniority in the promoted cadre. Even assuming, while not admitting, that OM dated 29/12 did not expressly repeal OM dated 12/3/02, but by necessary implication, it can certainly be asserted that OM dated 29/12/14 was issued to override OM dated 12/3/2002. Further, issuance of OM dated 3/8/16 referred to above sets at rest the above controversy. It is well settled principle of law that there is a presumption against an implied repeal. But this presumption will stand rebutted if provisions of the new OMs, that is 29/12/14 and 3/8/16, are so inconsistent with the old one, that is 12/3/2002, that the two cannot stand together. A.R. so and so. What follows from the above is that CATSA principle evolved by the Supreme Court revived with effect from 29/12/14 until 17/1/23 by necessary implication, and expressly with effect from 18/1/23. So this is what I would like to contend, my lord, for your lordship's kind consideration. And I can place the decision, my lord, where Honorable Supreme Court says that presumption is not to be readily drawn, but if the two cannot be reconciled, then, my lord, it has to be. Yes, my lord, that judgment I'll place, my lord. The judgment
No,
is,
which
my
of the two provisions cannot be
my
reconciled?
lord, provision contained in 12/3/2002, which speaks of consequential seniority,
And
and the other two, 29/12/14 and 3/16, which says they are not entitled. Because 29/12/14 says rosters are not meant for determining seniority in the promoted cadre.
rosters are not meant.
So, my lord, that means by virtue of a roster, if you earn a promotion, that will not count towards your seniority. And secondly,
No,
when,
no.
my lord,
Whether that is meant, or suppose the roster point where you were promoted is a little higher than the roster point where the general category will be promoted. But the roster appointee is subsequent. Then you cannot claim that I am in a higher roster point, therefore I am senior to you. Say normally, when normally when you go by the roster points, the man at roster 65 is always senior to the man at roster 66, because 65 comes in first.
That's right.
Here is a case that it will be post-based roster, meaning thereby, suppose the present roster going on is 81, this one example I gave, and the roster at 65 reserve category falls vacant. So one reserve category is promoted at roster 65.
yes, he will replace that.
Replace. This man now cannot say, I am 65, so I am senior to the 81. Or I am senior to the 80. This is what is meant by.
That is not the case of the petition.
May not be. That is what is the meaning of clause 4. Not 4. What is the 1.11?
When
1.11, it is in the context of the first paragraph.
Well, let us read that once, my lord, at page, page number 45.
These rosters are an aid to determine entitlement.
Of different categories.
The category
With regard to the quota reserved for them in the matter of appointment and promotion.
And
The
what,
next line.
and what is this? To implement the post-based roster system.
And they are not intended to determine the seniority in the cadre. That means.
That's what I said, that fitting into 65 at a later date, when 80 has already been fitted in, 65 will not be given the seniority merely because he is 65 and above 80.
Of course.
That's the only meaning we can
If that
conceive
is
of.
the meaning, that helps the cause of the general candidates.
It
If
may-
that is the case,
it may-
if that's the meaning which your lordships would like to ascribe, then that's what we want.
This is what it
Yes.
appears. So
So
that's
therefore, what we are trying to say in other words was, my lord, when they say they are not intended to
But
determine
they-
seniority in the cadre.
but that will not.
Let me give one example, my lord. Lordship has given one example, let me give another example. Now, supposing in a particular cadre, say up to roster point 50, it is filled up. Now from 51 to say 60, it will be now filled up. Now, my lord, a reserve category candidate who has already earned consequential seniority, he comes to the, my lord, within the zone of consideration, and his case is considered, and he gets a promotion against the particular roster point. Now, maybe that roster point is, my lord, say 50. Supposing if it is plain tribes, it will be one, say 51. STP is normally 1. So he will get the 51st post. Then, my lord, the general category, he gets promotion subsequently in the roster. That doesn't mean, my lord, he has earned promotion earlier, therefore he will rank senior. That is what is said by this. They are not intended to determine seniority in the cadre. That means a person by virtue of roster, when he earns a promotion, that is not for the purpose of determining seniority. These rosters are meant for determining to which slot you are entitled. That's all. That means, in other words, subject to what your lordship may say.
This is what we said in furtherance of that line, that slot seniority is not available. This is what it means.
If slot seniority is not available, that's the end of the world, my lord. Yes, that's
Suppose-
what we want.
Suppose the reserve gets promoted in the month of May.
Subsequent slot.
In the month of May.
Ah.
Slot may be 65. General gets promotion in the month of April. Slot may be 80. In this case, by virtue of getting the slot at 65, you cannot claim seniority over the slot 80. But on the other hand, suppose the man at slot 81 who will be subsequently promoted, he is otherwise senior in the original cadre. He will not get back his seniority over slot 65 because 65 was promoted before him by virtue of accelerated promotion. Meaning thereby, vis-a-vis the people whom he supersedes, he retains the consequential seniority, but he cannot claim seniority over the slot of 65 over the people who were already promoted before him and entered the other slots.
Then Lord,
This
then-
problem arises because of the post-based roster reservation.
No. What is just now, what has fallen from your lordships, then it's a proposition which supports consequential seniority. The example which your lordship has given just now, it supports, my lord, consequential seniority,
No.
which state of Assam says we don't have.
Does not. Consequential seniority is only when a man who is junior in the original cadre is promoted by accelerated promotion, goes to the next cadre. The senior in the original cadre is subsequently promoted. He will not get back his original seniority. That is called consequential seniority.
Yes, to that, now,
And,
second
and
example. is
here
okay.
is intended seniority in the cadre on the basis of post-based roster. Just because it is post-based, he can be slotted in any of the roster points.
My lord,
Someone may be in the roster point number 1 also.
my lord, instead of making this so complicated,
Making
my
it
humble understanding,
more simplified.
subject to your lordship, what your lordships may say. My lord, when from executive engineer to, say, from assistant executive engineer to executive engineer, a reserve category candidate, by virtue of roster, he gets a promotion, not on merit.
Hmm.
He gets a promotion.
Hmm.
Now, my lord, a reserve category candidate, a general category candidate gets a promotion after him.
Hmm. Hmm.
Maybe after a year.
Hmm.
And the reserve category candidate is still an executive engineer. So when the general category candidate earns his promotion, that too after inter-se assessment with all eligible candidates. He comes to the cadre, then my lord, he will regain his seniority. That is what we call catch-up principle. Now let us see, let us give a meaning to this 1.11. It says, my lord, these rosters are an aid to determine entitlement of different categories with regard to the quota reserved for them in matters of appointment and promotion. So in matters of appointment and promotion, slots are indicated. So respective quota man will go to the respective post. They will only get the promotion or appointment. That appointment or promotion will not determine the seniority in that category. Meaning thereby, the seniority will be determined by the recruitment rules. Otherwise, my lord, 12/3/2002 visualize a situation, recruitment rules makes no sense. Because I got a promotion earlier than the general category, therefore I'll be senior. So my lord, this is in my humble submission, this is what is understood. And by the clause 4 of 3/8/2016, again, my humble submission is, my lord, a reserved category candidate, the moment he earns a accelerated promotion and of course the consequential seniority, his case cannot be compared with a post meant for general category. But had it been a 12/3/2002 situation, he would have been eligible. So therefore, my lord, in my humble submission, from 29/12/2014, by necessary implication, my lord, 12/3/2002 was, my lord, impliedly repealed. And of course, we differ from 18/1/23 when they came up with the OM, when they
That's
say.
gone. Then
Yes.
it's gone.
Then
forever.
it's gone. So this is in.
Then means subject to if it is under challenge, what we.
Yes, it's under challenge. So this is the case, my lord. Today is already.
We'll continue tomorrow because
Yes.
these things, it takes
My
a little continuous here.
My lord,
Otherwise you tend to forget everything.
Well, I'll clarify on one point.
So we have to take a call on your impliedly this interpreting, they are not entitled to determine seniority. What kind of a meaning can be attributed to it? If it is this way, it is your way, it is other way, it is the other way.
Yes.
Then we'll have to take a call what clause 4 of the 16 OM actually means.
Yes.
To what extent it has been taken away, to what extent it has been not taken away, or it has been taken away wholly, or it has been not been taken away at all.
In other words, my lord,
We'll take it.
2002 notification visualizes one situation and 29/12/14 and 3/8/16 visualizes another situation. Therefore, there is a conflict. It cannot be reconciled. Therefore, it's a case of implied repeal. That is what we are trying to submit for your lordship's kind consideration. My lord, there is a stay order.
No.
My lord, we have filed one IA, it is pending for quite some time.
Mr.
Actually,
Venkatesh
what
Reddy,
had happened, my lord, we moved to writ appeal before the division bench. Then my learned friend made a submission based on which all the cases were taken. Although these are
which
single.
writ appeal?
Yes, my lord.
That
But there
item
are only 2 writ appeals were there, my lord.
37, I think.
Yes, 46,
3 writ
3 writ appeals.
38, sorry.
Then, my
38.
lord, my learned friend made a submission before court number 1 that there are related matters. Of course, issues are same.
Very good.
Therefore, all the matters were
41
taken.
is also a writ
That.
appeal.
Huh?
41. Sanjay Kumar Mohanto.
Sanjay Kumar Mohanto, I appear, my lord.
That is against the same Bhagavan Pata.
Same.
Same arguments, I think.
Same.
And only 38, Mr. M. K. Shuri, Equality Forum.
Yes.
That you take care of that. One is 5005 and the other one is 2 writ petitions in 5026.
My lord,
I think Mr. Chaudhary's appeal take care of the conclusion of the single judge in WPC 5026. And
my lord, there are 2 IAs, my lord. Today I am not placing lordship. Will kindly give us liberty to place those tomorrow, my lord. Let the promotion take place subject to the outcome of your lordship's proceeding.
Here I'll have to file an objection because my entire case is that if promotions are affected, it's in violation of the rules. Then I have a.
No,
case, sir.
provided if
Well, now
eventually.
since
No,
your
no.
lordship is.
so
against
we
the
have
matter-
started the hearing, let us conclude it.
Yes, that it is. I'll
But the conclusion may be tomorrow also.
Yes. Only
It's not that the conclusion will take another
Three
few
months.
months or few years and it will continue with us.
So that's the reason Lordship has rightly said, let the matter be finally.
Whatever it is, take a final call.
Yes, yes.
And
We are
this
for
is
it.
a matter, I'm quite sure, either of the two, we are bound to be dissatisfied, you are going in appeal. That will be finally decided. If it is in your favor, he will go. If it is his favor, he will go. And if it is nobody's favor, Mr. Majumdar will go.
But somehow we'll
So,
have to go to pay.
so,
Mozumdar perhaps will not go.
so let us finish it off here.
Mazumdar has not filed an appeal.
Anyhow,
though he supports.
Let us finish it off here, whichever way it goes. Instead of keeping all this pending.
Can I make a small submission with the Lordship? It's 5 minutes. My Lord, Lordship will take up page 81, where the entire argument is on the OM of 2014. I'd just like to clarify one point.
81?
Page 81 of the writ appeal. SC/ST candidates appointed on merits. Well, 3 clauses I'll read.
What is this 81?
81 is
It's
the
a part of what?
part of 29 to 29, 12, 14, part of.
The same
writ
one?
appeal, yes, well, please,
Yeah, read it, 45.
yes.
It's
40.
the same document, unnecessarily
here,
two
if I-
markings in two different
Yes.
ones.
Well, here I might take up one point, only 5 minutes I'll take. I'll read out, there's the guidelines which stipulates how SC/ST candidates appointed on merit has to be slotted. So if I may read 3.1. Uh, 47 is the operative part. 47 is the page 47. 3.1. 3.1, if I read, Lordship. Here I'll show that the guidelines are very specific. In case of direct recruitment and promotion, SC, STP, ST, H, who has been appointed on their own merit and owing not to reservation, should not be shown against the reserve quota. They are to be adjusted against unreserved quota. 3.2. If any unreserved vacancy arises in the cadre and there is SC, STP and H candidate within the zone of consideration in the feeder cadre, such cadre candidate cannot be denied promotion on the plea that the post is not reserved. Such candidate shall be considered for promotion along with other candidate, treating him as if he belongs to the general category, in terms of R.K. Sabharwal. In case he is selected, he shall be appointed to the post and shall be adjusted against unreserved post. And the last is 3.3. Similarly, SC, STP and STH candidates appointed on their own merit by direct recruitment or promotion and adjusted against unreserved post shall continue to remain their status of SC, STP and SH and shall be eligible to get benefit of reservation in the next or future promotion event. Well, this is in contravention of clause 4.
Mr. Majumdar. We come to page 45. Following guidelines have been prescribed in order to implement the post-based roster reservation. Where is the provision for post-based roster provision? What you are trying to implement? Implement means always there is something prior existing, not providing for itself. What you are trying to implement? That will give the answer to the entire 1.1. Just I'm reading a few left. Following guidelines have been prescribed in order to implement the post-based roster. Consequent upon amendment in Assam so and so, acceptance or recommendation of that committee regarding quantifiable data on backwardness so and so, and impact in overall efficiency. Okay, these are the 3 considerations. The following guidelines are to implement post-based roster. So there is something post-based roster reservation which is existing, and you are trying to implement it. This provision is existing somewhere. Where is it? It's a court judgment or it's some statutory provision, some,
No.
what you are trying to implement?
Possibly this OM is for the purpose of my lord implementing the Supreme Court judgment, which is there will be post-based.
Which is that judgment?
Yes, yes.
Don't worry, it will, clock is doing its own work, we are doing our own work. Because what Mr. Chaudhary submitted, we have to consider it on the basis of that. See, there is already a provision. Okay, that only 10 people can remain in this courtroom at a point of time.
Yes.
Fine. Tomorrow, the court master issues a notice. We are implementing that one, that henceforth only 10 people will remain.
That means it is already there.
It's already there. There is another way, court master issues a notification that from now onwards, only 10 people will remain in the courtroom.
That means it's a fresh
That itself is the
beginning.
decision. Other one is, so here when the language is implement the thing, it must be pre-existing. What you are trying to
I'm
implement?
just clarifying.
So once that provision is clear, what you are trying to implement, then we can give a meaning to it, the intended seniority.
Well, I'm coming to that. But will you kindly see, kindly take up this Act of 1978 from there and point. It is because of the amendment in the Act.
5A.
Madam,
A post-based roster shall be maintained.
yes, if this, if
To give effect to reservation, such roster shall be based on model roster and be adopted. Each appointment shall prepare post-based roster register shall be.
Madam, in 2000, this 5.
Post-based roster. What is post-based roster?
Madam, that is fine. I'm coming. Lords may kindly take up this Act, section 5 of this Act.
We are ready.
Madam, this was amended in from with effect on 21/8/2012.
True.
Prior to amendment, it was not post-based, also it was vacancy-based. In order to.
No, what is the difference between post-based and vacancy-based?
Madam, moment a vacancy,
See.
madam, yes.
Earlier, there was vacancy-based reservation.
Supreme Court clarified that it is
Now we want to make it post-based.
Post.
What is the difference in implication of the
It has
two?
got direct relation with the replacement theory, my lord.
Replacement theory.
Yes.
Then how does this, they are not intended to determine seniority in the cadre,
My lord,
has to
this-
be given a meaning as regards the consequential seniority or as regards seniority that may be affected or claimed in any manner because of the change from vacancy to post-based.
No, my lord. It simply says it deals with the post-based roster.
So,
And
no, this deals with implementing post-based roster.
the wordings may be implementation of post-based reservation. It's actually post-based.
Mr. Majumdar, starting with you, gave you an example.
Well, this,
10 lawyers will
Whereas-
be allowed in the court. One will be just a notification. Tomorrow you'll find on notice. Not beyond 10 will be allowed.
my lord,
That COVID days we had it.
my lord, that I understand.
Another one is, he will say, in implementing a decision, from today 10 will not. Implementing always means existence of a prior
My lord,
requirement.
Implementation comes because of the amendment in the Act, my lord. Lords, will you kindly see the Act.
So now we want to know
My lord,
from vacancy based, you are now switching over to
Post-based roster,
Post-based.
roster.
So
And
just a minute. Did the principle of consequential seniority not exist when it was vacancy based? It existed.
it exists. It has got no
Ha.
direct relation, man.
Consequential benefit seniority also existed after it was switched over to post-based.
Post-based roster.
So this seniority, why should we construe that it is related to consequential seniority because of this provision?
It is not related, but even I am saying, madam.
But Mr. Chaudhary submitted the otherwise.
It is not related because if a person.
They are intended not to. What is not intended to give seniority? if switching over from vacancy base to post base gives some kind of a seniority to any person, not consequential seniority, any other kind of seniority which did not exist in vacancy reservation, vacancy base, but appears to have been created or claimed or to be in existence when it switched over to vacancy base, this switching over to vacancy base will not entitle to any such seniority. Can you attribute any meaning other than that meaning?
My submission will be, this OM of 29 December 2014 does not deal at all with the determination of seniority. That is why it clarifies once again in 1.11.
It does not deal with a
No.
claim of this thing.
No.
So then the entire submission, Mr. Chaudhary, is nullified by what you have submitted.
My submission will be like this matter. This, whether it is post-based roster or it is vacancy-based roster, this has got no direct relation with the determination of seniority vis-a-vis the
Consequential.
promotion by virtue of reservation.
That is consequential.
Yeah, consequential.
Nothing
My-
to do.
no.
Okay, we take it.
Because, my lord,
This is all we are trying to suggest from initially also, but Mr. Chaudhary submitted
yes,
by referring to this his submission in that
this is only for the purpose of roster.
that
Earlier it was vacancy based.
para 8 of his written submission, that 14 and 16 are so inconsistent with the old one that two cannot stand together. Implied, therefore it is by necessary implied repeal. We have to reject that. Going by what you were submitting.
And this OM of 2014 deals with
Does the issue before what is raised by Mr. Ken Chaudhary, that does 2014 in any manner repeat 2002,
and that is a-
providing for
and
consequential?
that is a different aspect. So far as the relationship of this OM with the question of determination of seniority, whether it will be catch-up theory or consequent seniority, my submission is there is no direct relation, no relation at all.
Nothing is there.
No,
So this is irrelevant for that purpose.
yes,
We
that is-
maintain it that way. It is not relevant.
yes.
So if this is not relevant, 2002 consequent seniority remains in spite of 2014. Now we'll examine to what extent 2016 had repealed it.
My submission will be 2014, if it goes, and then 2016 when it comes, there is an implied repeal of 2000. That was my argument before
Of
the honorable Senate.
2002.
Yes.
How?
For the simple reason that even if this OM of 2014 was not directly set aside, but when the basis of this OM 2014 was set aside by the almost single judge in the earlier petition.
So the 2014 impliedly goes.
Goes. If it
So
goes,
2014 impliedly goes,
my lord.
if I accept your argument,
My
then
lord.
2002 remains.
No. If
2002 was not say,
my lord, 2014, of course, when 2014 deals with post-based roster.
no,
So that is,
no.
no matter my submission.
By
my
the
lord,
judgment in equality
Madam, my-
forum, does the 2002 also goes?
Equality forum. My lord, when-
Equality
yes,
forum took away the basis.
It goes, my lord, because my lord,
2002 also goes.
yes, my lord. My lord, my submission, all right, I'll clear it tomorrow. My submission is, my lord, I'm just giving you.
Yes, matter.
Well, if
We have to
my-
continue with this.
Yes,
and
well, a
finish.
very interesting point. If my learned friend's submission is to be accepted that a 2014 is non-existent, then why is he making a submission that the model roster is of 2012? And the post-based reservation, the power of implementing the RK Sabharwal is 2014 OM.
My lord,
Can he
My
now say that the
My lord-
2014 OM doesn't exist
My
for
lord-
my case?
my lord,
And at the same time say that the 2012 amendment has brought in post-based reservation.
my lord,
So he cannot, the state government cannot.
We'll
make this
take about 2 o'clock.
Yes,
tomorrow.
Madam. It's a very
tomorrow
interesting.
at 2 o'clock.
The Lordship has rightly
My
touched.
lord, my lord, I'm making just one second sentence. I make it very clear. My submission is, I have not dealt with this 2014 at all earlier, even before the on-simulation. My submission is, by virtue of OM of 2016, impliedly to 2002 has gone.
That we'll hear separately.
My-
Tomorrow we will.
16,
I
14, we are deciding the two issues separately.
Yes. I did not deal with
We
this
are-
2014 OM because
Ah.
there is simple reason, my lord. 2014 OM actually has come because of the Supreme Court judgment and consequent
Post-based.
amendment of
Post-base, that is
Yes,
post-base.
yes.
Post-base.
So that will remain.
Hmm.
What I'm saying is, as far as reservation in promotion is concerned, for that, we had to take a call after the judgment.
And you took it by 2016.
16. yes.
Now, what call you had taken 2016? We'll try
Catch
to
up,
analyze
catch
and
up.
find
In
out
fact,
what
our
it is.
submission is catch up during
In
this.
fact, now
Yes.
there is a difference between the submission of Mr. Ken Chaudhary and Mr. Majumdar. Because he says that 2014, he is in my own page. 2014 is post-base, 2002 is 85. Two separate.
Let him not presume everything today. We'll argue.
Yes, it's a continuous. Obliged.
No, these are recorded proceedings. Don't worry. If any confusion, we can replay the recording.
Yes.
What you think?
Yes. Obliged. Two.